Thank you, Courtney. Thank you, GRS, for having us here. My name is Danielle Brennan. I am a board certified specialist in condominium and plan development law here with K. Bender Rembam in its Palm Beach Gardens office location. This is one of, how many do we have now? One, two, three, four, five different office locations throughout the state of Florida. We have our main office in Pompano Beach down in Broward County. Winter Springs office in Seminole County and Tampa office in Hillsborough, and we do offer some office space in Miami-Dade by appointment. I am one of 24 attorneys here with K. Bender Rembam. We do have 8 other attorneys who are board certified specialists in condominium and plan development law, and we also have one who is board certified in construction law. We exclusively provide expert legal services for community associations throughout the state of Florida. You name it, we've probably done it. Governing documents from scratch, governing documents, amending, restating them, contracts, easements, I mean, what have you, enforcement, violations. We've done it all. So there's probably not an issue out there we haven't handled through to conclusion. As Jeff and Courtney both mentioned, this is the HOA Homeowners Association's board certification course. If you are on a condo board or on a cooperative board, this is not the course for you. But we do offer them quite frequently. I want to say like once a month. And you can go to our website, kbrlegal.com. We have a calendar that has all of our events scheduled. You can register there. This is not legal advice. A lot of what I'm going to tell you is based upon Florida statutes and case law, right? But we have our governing documents that are specific to our communities. So you really want to focus in on your governing documents and then the interplay with Florida law and the case law. Some of these things may or may not be applicable to your association based upon what you have in your governing documents. All right, so I'm going to go ahead and share my screen. We do have a PowerPoint presentation for you guys. You will be receiving, once you do the evaluation, you will be receiving a copy of the presentation that I'm going to do for you right now. I may have some time for questions at the very end if you put your question into the Q&A, but like Jeff had mentioned, a lot of your questions may be answered by later material in the presentation.
That's correct. And one thing I'll mention too, Danielle, as you get ready for the next slide, you don't have to take crazy notes if you choose not to. You will be able to download and save today's slides after you fill out the required evaluation at the end. Danielle, back to you.
Yep. And if your question hasn't been answered and you have something that's like a general legal question, not necessarily specific to your association, you can always feel free to email me. I try to get to those emails as soon as possible and respond. All right, let's go ahead and get started. Some personal information about me, what I do here, and what I've done in my legal career in the past. So why are we here? This isn't, an existential question. This is a question pertaining to this course. So Florida legislature requires that within 90 days after being elected or appointed to the board, you have to complete an educational curriculum that's administered by an education provider that's been approved by the Department of Business and Professional Regulations, which we have. That's why we have that official course number here. And the certificate of completion is going to be valid for 4 years, and you have to redo this education course at least every 4 years. The education curriculum has to cover certain points, which are definitely going to be discussed later on: financial literacy, transparency, record keeping, levying of fines and notice, and meeting requirements. Now, if you don't get your board member certification course done, you're not kicked off the board, but you are suspended from board service until you comply with that requirement. Now, during that time of suspension, the board can temporarily fill that vacancy, but once you do complete the education certificate and provide it to your secretary, you're automatically back onto the board. The association has to keep that certificate for 5 years after your election. However, the failure to have that written certificate on file does not affect the validity of your board action. But you really do want to make sure that you do have it timely provided. You will be receiving that certificate. May take a few days depending upon, how busy the classes, how many people are in attendance, but those will be sent to you after you do the evaluation. As Jeff mentioned briefly, there are continuing education requirements based upon the size of your community. If you have less than 2,500 parcels, then you have to complete 4 hours of continuing education annually. And if you have more than 2,500 parcels or 2,500 parcels or more, then you have to do 8 hours of continuing education annually. And you may think to yourself, well, that's like a really high number. Well, this requirement was put into place because of a specific situation that happened in Florida, down in Miami. So yeah, 2,500 is particular to that. We do have some continuing education courses. This is not it, but we do have them. You can go again to kbrlegal.com, our calendar, and we do have all of our events listed on there. So let's talk a little bit about the statute. So homeowners associations and condominium associations, they're similar in a lot of ways, but different in so many other ways. A homeowners association can exist without Chapter 720 Florida statutes, whereas in a condominium, it only exists because of Chapter 718 Florida statutes and its previous version, which was Chapter 711 of the Florida statutes, because they needed the statute in order to create title to that block of air that is the real property. HOA owns the common areas in its own name. However, in a condominium association, all the owners own an undivided interest in the common elements. HOA boards typically decide issues concerning material alterations, unless their governing documents would require membership approval. But it's very different in a condo. A Florida condominium association cannot make material alterations without 75% approval of the unit owners unless some other approval requirement is provided in their declaration. And these are just a couple of the differences. There are a lot more. So we know that Chapter 720 is our Homeowners Association Act, and that's what applies to our homeowners associations throughout the state of Florida. But we also know that every single year, the Florida legislature likes to play with these statutes. For HOAs, not so much as with condominiums. Condominiums, every single year, something gets changed. I actually don't think that there were any changes to the HOA Act this past legislative session. They were too busy dealing with structural integrity stuff and milestone inspections for our condominium associations. So, since the law typically changes every single year, which version of the law applies to our association? Well, the substantive law that's in effect at the time of contract, meaning at the time the declaration is recorded for our purposes, that law is incorporated into the contract as if it were actually written in that contract. And there are constitutional due process rights that protect us from retroactive application of laws that would adversely affect or destroy a vested right, that would impose or create new obligations or duties in connection with a previous transaction, or impose new penalties. So if a law is created that would affect those substantive rights, they don't go back in time. They're only forward looking. However, there is a little bit of a caveat here. Kaufman language. Kaufman is a name taken from a condominium case. And basically, Kaufman language is that as amended from time to time, you see there. If your declaration provides that its subject is Chapter 720 Florida statutes as amended from time to time, then each year's legislative changes that change in a substantive way will change your documents. Now, in the event the declaration does not include that Kaufman language, then we have to take a careful analysis, right? Does the legislation itself provide guidance? Is it retroactive? Meaning, is it for a public policy reason? For example, there was a law change in HOA Act basically eviscerating any provisions that are discriminatory, right? And that's for a public policy reason. Because it is a public policy reason, it's going to be applicable to your association, notwithstanding that you don't have any Kaufman language. Um, Now, Kaufman language, like I said, only affects substantive rights, not procedural rights or procedural laws, right? If it's procedural, then that legislation applies. If it's substantive, then more likely than not, that legislation is not going to apply. Now, what's the difference between these two types of laws? Procedural laws provide means and methods for the application and enforcement of existing duties and rights. So this is, for example, timelines. You have to provide 14 days notice of membership meetings. If they change that notice requirement to 15 days, that change would still affect your association because it's a procedural measure. Whereas substantive laws, they're actual legal duties and rights that become vested. So those are the ones that are going to be protected by that constitutional due process. Although we are homeowners associations under Chapter 720 for the Florida statutes, all of our homeowners associations are also organized as corporations, and the vast majority of them are not-for-profit corporations under Chapter 617 of the Florida statutes. Sometimes there may be conflicts between our Florida Not-for-Profit Act in 617 and our Homeowners Association Act in Chapter 720. So what do we do in the event that there's a conflict between these two? Well, the specific controls over the general, meaning the provisions of Chapter 720 will control over the contrary provisions of Chapter 617. And for the most part, the provisions of Chapter 617 are, vastly procedural and very general in nature. Now, we also have three different governing documents, minimally three different governing documents that are recorded. Our declaration of covenants, restrictions, what have you, articles of incorporation, and our bylaws. The declaration is essentially like your constitution. It sets forth the rights and the relationship between the association and the owners. Your articles of incorporation, that is your corporate establishment document. It says we are not Florida not-for-profit corporation. We have directors who are elected, may provide for some qualifications of directors. We have officers. These are our officers, might provide some qualifications for that, their indemnification rights. This is a document that just merely sets forth and creates that entity that is the association's corporation. And your bylaws. Bylaws are vastly a how-to procedural document. How do we hold a membership meeting? How do we hold a board meeting? How does the board adopt its budget? Things like that. Now, these documents in a perfect world will all be done together and won't have any conflicts. However, we don't live in a perfect world, right? And we're all human. So sometimes there are conflicts between the declaration, the articles of incorporation, or the bylaws. What do you do in that event? Well, there's the old expression, a little dab will do ya. You follow your declaration, then your articles, then your bylaws. That's the hierarchy and the priority of the governing documents. Of course, there are exceptions to the rule because as lawyers, we love our exceptions to the rule, right? Keeps us in business. Sometimes the statutes will say, unless otherwise provided in your bylaws. Well, in that instance, if there's contradictory language in the articles, we're not worried about that. We're looking only at our bylaws, not our articles. So we would follow what's in our bylaws. Speaking of bylaws, let's go into some of the nuts and bolts about membership meetings. And these are typically what's provided in your bylaws. So we have two different types of membership meetings. We have annual members meetings and special members meeting. The annual members meeting, everybody knows very well. It's held once a year and you're holding your election at that annual members meeting. Every other meeting other than the annual members meeting is a special meeting. You can have different ways of how a special members meeting gets called in your bylaws. But generally speaking, if there's nothing there, then we fall back on the statutory requirement. Then it can be called by the board of directors or when at least 10% of the total voting interests of the association petition for it. But again, this is just a statutory standard if you don't have something in your governing documents providing otherwise. The annual members meeting does not require the use of an agenda. However, we always advise that an agenda be provided. Special members meetings must include an agenda because the purpose for those special members meeting is limited, right? We're calling this special members meeting for a specific purpose. So we do need to state what that purpose is in an agenda, and then the business that's conducted at that meeting is limited to those stated purposes. For our notice requirements, notices have to provide the date, time, and location for the meeting. If your bylaws don't have some certain requirement, it does have to be mailed, delivered, or electronically transmitted to all owners at least 14 days before the meeting. Whoever is sending out that 14-day notice does have to execute an affidavit saying that they have sent it out. And then that affidavit gets kept with the association's official records together with a copy of the notice that was sent to the members. Notice has to be mailed or delivered to the address identified as the owner's mailing address in the official records of the association, or electronically transmitted if the owner has consented in writing to receive notice by electronic transmission. An electronic transmission can mean email or facsimile. If somebody time traveled from the 90s and and still has a fax machine, right? So for electronic notice requirements, again, you can send electronic transmission notices, either email or fax, so long as the owner has provided their written consent to receive notice by electronic transmission. The emails and fax numbers that are provided by members to receive notice that way have to be removed from the association records if the member revokes consent to receive notice by electronic transmission. However, the association is not going to be liable if there's an erroneous disclosure of that information. Electronic transmission cannot be used as a method for giving notice of a meeting that's called in whole or in part for a special meeting of the members to recall a director. So even if you have those written consents to receive notice by electronic transmission from members, if that meeting is going to be for recall in whole or in part, then you do have to use mail or delivery. For those associations that actually do have broadcast notice, that is an option. Like if you have a closed circuit TV system or something like that, you can post your notices that way. Just make sure that they're posted for long enough that an average person can read the contents of the notice. By January 1st of 2025, so this has been around for a little while, an association that has 100 or more parcels has to post the notice and agenda of each members meeting at least 14 days before the meeting. And it has to be a conspicuous posting here. It either needs to be on the homepage of the website or on a subpage that's labeled notices, which is conspicuously visible from the homepage. The association also has to post any document to be considered and voted on by the members during the meeting. For example, maybe they're voting on an amendment. Well, you kind of have to post a copy of that amendment on the website, and it has to be at least 7 days before the meeting. Why the difference between 14 and 7? I really have no idea. I would suggest you just do it all at the same time. That way you don't have to think about it 7 days before the meeting. Now that we're at the meeting, right? So owners have the right to attend all membership meetings and to speak at any meeting with reference to all items open for discussion and anything that's included on the agenda. Owners have the right to speak on any item for at least 3 minutes. If your documents provide anything less than that, they're still going to be able to speak for at least 3 minutes. And mind you, this is a minimum. It's not a maximum. So they you may want to consider adopting some rules and regulations governing the frequency, duration, and other manner of owner statements um, that would set a maximum. Again, has to be at least for 3 minutes, but the association does have the authority to adopt those rules, so certainly consider doing that. Membership meetings have to be held in a location that's handicap accessible if a handicapped person has the right to attend the meeting and it has requested it. And an owner can tape record or videotape membership meetings. And the board, again, should absolutely adopt some rules governing the taping of meetings. Quorums and decisions at membership meetings, unless a lower number is provided in the bylaws. 30% of the total voting interest of the association constitutes a quorum of the members at a membership meeting. I have seen it lower. So you certainly want to be checking your bylaws for that. Um, Unless otherwise required by law or your governing documents. Once you have a quorum of your members at the meeting, the affirmative vote of at least a majority of those voting interests that are there can decide and make decisions on behalf of the membership. Again, this can change vastly depending upon what your governing documents say. For example, amendments could be a 75% approval requirement. Your governing documents may have a material alteration vote requirement that's 66 and 2/3%. You want to be making sure that you're looking at your governing documents to determine what the correct approval requirement is. Now, for those owners who cannot physically attend a meeting to vote, they have the ability to attend by proxy, right? Unless otherwise provided in the Florida statutes here or in the governing documents, they have the right to vote in person or by proxy. There are certain requirements that make a proxy valid. It has to be dated, has to include the date, time, and place of the meeting for which it's given, and be signed by the person who's authorized to vote. Now, some governing documents do require that the voting member be designated in writing to the association for lots that are owned by multiple people or owned by a trust, corporation, or some other entity ownership. So you want to look at that as well. A proxy is going to be effective for that specific meeting that it's stated on the proxy and any adjournments of that meeting, meaning continuing the meeting to a date, time, place certain, so long as it's not more than 90 days from the date of the meeting for which the proxy was given. Those proxies have a lifetime of 90 days. So if you go beyond those 90 days, this proxy is no longer valid and you're going to have to redo the process, right? And that's painful. Proxies are revocable at any time by the person who executes the proxy. Again, that's going to be our voting member. And the proxy holder can appoint in writing a substitute to attend if the proxy form allows them to appoint a substitute. And we usually include that in our proxy forms. You don't have to have the original proxy in order for it to be effective. You can use a copy of it so long as it's a complete copy of that proxy. Now, there are two different types of proxies. There are general proxies and limited proxies. A general proxy says, hey, proxy holder, you go, you represent my attendance at the meeting, and you vote on whatever matters that come before the members for a vote any which way you want. I'm not going to tell you how to vote. You vote however which way you want. A limited proxy does the same thing as to attendance, but it instructs the proxy holder how to vote on whatever the particular matter is. So on the limited proxy, it'll state the vote, and then the owner, the voting member, will check off whatever it is their vote is, and then will send in their limited proxy. So they're very different. And for an HOA, unless your governing documents require voting by limited proxy, you can use a general proxy for voting. Very different from a condo. Condo, you have to have limited proxies. Now, electronic voting. We're seeing this being used more and more by owners, and it really has been great for larger associations because it makes the tally so much easier. The use of an internet-based online voting system can be established by the board. There is a specific board resolution that has to be adopted. It has to provide that the members will receive notice of the opportunity to vote through an online system and establish reasonable procedures for members to opt in writing and to opt out in writing, either electronically or in writing, excuse me. That board resolution has to be adopted at a board meeting that's noticed at least 14 days before the meeting by mail, delivery, electronic transmission, and conspicuously posted in the community. So this has that heightened board meeting notice requirement, and we'll go over the board meeting notice requirements very soon. The association can conduct all types of membership votes through that online voting system. Again, it's a two-step process. Board resolution, then the owners have to opt in writing or electronically in order for that owner to take advantage of the electronic voting system. So once the board has the resolution adopted, then you would be sending out some kind of consent form saying, hey, we have this ability to vote via the online voting system, provide us your written consent. And there are a lot of different vendors out there who have systems in place that can get those different consents as well. And I'm trying to think of like the cost. I know cost is based on how many owners actually opt in and how many votes you do per year, but I feel like I recall it being fairly reasonable. Um,
Correct.
Pardon?
I'm just saying you're correct. It's
Yeah.
not only is it fairly reasonable, but the models are similar to what you mentioned based on how many people actually choose to participate.
Right. And there are a bunch of different ones. Get Quorum, Vote HOA Now. I'm sure there are others,
Yeah,
but they all of their systems meet the requirements, which are on the next one here. So when you vote electronically through the system, you're voted as being in attendance as well for quorum purposes. The online system that is used by the association has to meet all these criteria. If your election requires a secret ballot voting, similar to a condo style, then the system has to be able to remove whatever personal identifying information may be from that ballot to ensure that the ballot is completely secret. There needs to be a method for the member to confirm that their device communicates with the system at least 14 days in advance of the meeting at which they're going to be voting at. They need to get a receipt of their vote having been transmitted. So you and typically all of these things are going to be covered by your service provider. Now, falling into elections here. So our election of directors, excuse me, as I mentioned before, this is occurring at the same time as our annual meetings. If there's a vacancy on the board that's caused by the expiration of a term, then it's filled by an election. The elections have to be conducted in accordance with the procedures set forth in the governing documents. You know, I find a lot of times we love our managers, don't get me wrong, but a lot of managers for our HOA communities will run the election like a condominium because that's what they know and that's what's very well known. However, a lot of HOA documents don't provide for that type of election procedure. Typically speaking, in an HOA, you only need that 14-day notice before the annual meeting. Nominations are taken from the floor of the meeting. That means people will then handwrite their ballots with the names of the people and then check them off, vote for them, cast their ballot that way. So you want to be very careful about the way in which your elections are being run to make sure that you're checking your governing documents and making sure that the process that's used is what is dictated by your governing documents. Unless otherwise provided in your governing documents, a quorum of the members does need to be established in order to conduct an election, and including any other business that the association might be conducting at the annual meeting, for example, voting on an amendment. Unless otherwise provided in your governing documents, directors are going to be elected by a plurality of the votes cast, not by cumulative voting. So if you have 3 board member positions open and there are 7 candidates, you'll be able to vote for up to 3 of those directors on your ballot, or 3 of those candidates on your ballot. For candidate eligibility, all members are eligible to serve on the board unless otherwise disqualified. And here are some of the things that would disqualify them from the board. If they're delinquent in the payment of any monetary obligation to the association, on the last day that they can nominate themselves, they cannot be on the ballot. And sometimes, like I mentioned, if it's nominations from the floor, if they're delinquent, let's say when you issue notice of that meeting, but they pay up and they're not delinquent on the date of that meeting, well, then they're still eligible on that basis. So because they've made themselves current. A person who has been convicted of a felony in Florida or U.S. District Territorial Court or has been convicted of an offense in another state, which would be a felony if committed here, is not eligible to serve on the board unless their civil rights have been restored for at least 5 years as of the date on which they seek election to the board. A person who has pending criminal charges for forgery of a ballot envelope or voting certificate used in an election, felony theft or embezzlement involving the association's funds or property, tampering with physical evidence, which would be destruction of or refusal to allow inspection or copying of the official records in furtherance of a crime, or obstruction of justice, cannot be elected to the board. Remember
And
how yes.
so sorry. Just folks, I'm going through the attendees, and make sure you have your chats enabled. If your name doesn't show up, I'm going to be sending you a message to give me your proper name so your certificates are correct. So Indian River Pines and others, please type your names into the chat. Danielle, I'm so sorry for the interruption. I just want to make sure
And
everybody
it's
gets
okay.
what they
No,
need.
gives my voice a break, right?
And also, folks, you don't have to do it. Only type your names into the chat if I reach out to you. Okay, don't go ahead. Only if I reach out to you. So hold up, you're all going cuckoo there. Don't worry about it. And then the other thing is, somebody like Tom. All questions about the class should go into the Q&A, not into the chat. Okay, sorry, so sorry. Back to you.
No worries. So recall that when I was talking about the continuing education requirement, that it was set at that particular number because there was an issue in a case, um, however many years ago it was, 2 or 3 years ago. Well, this was also part of that legislation here about these pending criminal charges. Nominations, like I mentioned before, um, unless your governing documents have a pre-nomination procedure, meaning nominations before the annual meeting, you're going to be doing your nominations from the floor. If you do have that process, then you're not required to allow nominations from the floor of the meeting. I've seen this as a big trend for our homeowners associations as they're moving to a process that's similar to the condominium association, where they have the 60 days first notice, allow nominations until 40 days before the meeting, allow for candidate information sheets until 35 days, and then we'll send out ballots with the second notice to be returned in the double envelope system. So you may want to consider that for your association if you allow nominations from the floor. It makes for an easier election process, certainly on the day of. So here we are at our election day. An election is not required unless more candidates are nominated than vacancies exist. So mentioned before, if we have 3 board seats open and only 3 people nominate themselves, or even maybe even fewer, then we're not going to be balloting. Those people are going to be automatically put onto the board on the night of the election. If you have more than that, then yes, you would need balloting. Let me see. Balloting here. Members have the right to vote in person or by proxy unless otherwise provided in the governing documents, as I mentioned before. If the governing documents allow voting by secret absentee ballot, then we're going to be following that condominium style with the double envelope. Your ballot has to be placed in an inner envelope with no identifying marks, then put into an outer envelope that gets delivered to the association, having the name of the voting member, the lot for which the ballot is cast, and that voting member's signature. All ballots and proxies are tabulated on the day of the annual meeting. If there's more than one ballot submitted for a parcel or a lot, the ballots for that lot are disqualified, and any vote by ballot received after the close of balloting is not going to be considered. Unless your bylaws provide otherwise, directors will serve a 1-year term. It's fairly common for the 1-year term, but I have seen plenty of associations that will use like a staggered 2-year term. Any challenge to the election process has to be commenced within 60 days after the election results are announced. After that 60-day mark, you'll be looking at doing a recall, and you can institute a recall until 60 days before the election. And we'll discuss recall a little bit later. Any election dispute must be submitted to binding arbitration with the Division of Florida Condominiums, Timeshares, and Mobile Homes. This is one of the 2 areas in which the division has jurisdiction with HOA associations. The other was with regard to recall. Or you can file that challenge with the Court of Competent Jurisdiction. Election disputes that are submitted to binding arbitration with the division have to be conducted in the manner that's prescribed for condominium associations, and there are procedural rules in the Florida Administrative Code that are adopted by the division that also have to be followed. So for our officers, generally speaking, we're talking about our president, vice president, secretary, and treasurer, though your documents may also provide for an assistant treasurer or assistant secretary or multiple vice presidents, something that you'll have to look at your governing documents. But typically, like I said, it's going to be those 4 different offices. They're usually appointed by the board immediately following the election of the directors at the organizational meeting of the board. Directors usually cannot vote by proxy or by secret ballot, but secret ballots can be used in the election of officers. And there's certainly no prohibition, at least under the law, against changing officers midterm. So if you've decided, you know what, we don't really like this person as our president, they can be changed by the board at any time. As I mentioned before, that case that happened, however many years ago it was, and the new pending criminal charges that would make a person ineligible to run for the board or serve on the board. There are certain fraudulent election voting activities that were added in that same legislation. So a person who engages in any of the following acts of fraudulent election voting activity commits a first-degree misdemeanor. So there is a criminal charge here: willful and falsely swearing to or affirming an oath and affirmation, or falsely procuring another person to falsely swear to or affirm an oath or affirmation in connection with or arising out of voting activities, perpetrating or attempting to perpetrate or aiding in the perpetration of fraud in connection with a vote cast, to be cast, or attempted to be cast, preventing a member from voting or preventing them from voting as they intended by fraudulently changing or attempting to change their ballot envelope, vote, or voting certificate, menacing or threatening or using bribery or any other corruption to attempt indirect member when a member is voting. And yes, it goes on. Giving or promising directly or indirectly anything of value to a member with the intent to buy their vote. However, you can still have like your campaign rally type things, if you're serving hot dogs, you have campaign pins or stickers, you can still do that. That's not considered buying their vote. Using or threatening to use directly or indirectly force, violence, or intimidation, or to coerce them by intimidation to induce or compel them to vote or refrain from voting in an election or on a ballot measure. So, so it must have been, 2 years ago. Each of the following acts constitutes a first-degree misdemeanor. Again, more criminal charges here. Knowingly aiding, abetting, or advising a person in the commission of fraudulent electronic voting activities. So any of those things that we discussed previously on the 2 previous slides. Agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent voting activity, or having knowledge of a fraudulent elections voting activity, and giving any aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. Now, I mentioned that vacancies on the board that are created by the expiration of a term are filled by an election. Well, what if it's a vacancy occurring on the board before the expiration of a term, except by recall, which again we'll go over at the very end, I think. Um, the vacancy can be filled by an affirmative vote of a majority of the remaining directors, even if the remaining directors constitute less than a quorum, or by the sole remaining director. Otherwise, the board can elect to have an election to fill that vacancy. And if you do choose to have an election, then you have to conform the election to the election requirements set forth in your governing documents. Unless otherwise provided in the bylaws, a board member that's appointed or elected to fill a vacancy occurring on the board before the expiration of the term serves for that unexpired term of the seat being filled. So now you're on your board of directors. What do we do? The officers and directors have a fiduciary responsibility to the owners. They must act reasonably and use their reasonable business judgment rule. You don't have to be right 100% of the time, but you better have something to back up your decisions, why you decided to choose something a certain way. Unless otherwise provided in your governing documents or by law, the association's powers are exercised by the board. And generally speaking, unless the authority is specifically granted to the members, whatever is in your governing documents that refers to the association, that's something that's going to be exercised by the board. Unless it's been delegated, no one board member should be making decisions for the board. Everything needs to be done by the board unless some kind of authority has been delegated either in your governing documents or by decision of the board. Directors cannot vote by proxy or by secret ballot, again, except that secret ballots can be used in the election of officers. And the members of the board can use email as a means of communication, but you need to be careful that you're not voting on an association matter via email. And for the most part, board members will email about topics that they want to include on an agenda so that they can actually vote on it at a properly noticed board meeting. All board meeting notices have to include the date, time, and place for the meeting, and you do have to include an agenda for all of your board meeting notices. An assessment cannot be levied at a board meeting unless the notice of the meeting provides a statement that assessments will be considered and the nature of those assessments. Typically, our board meeting notices only require 48-hour notice conspicuously posted in the community, except in the events of emergency, right? However, as we've already mentioned, there are certain exceptions to that. The first one we talked about was that 14-day notice that has to be sent to the members and posted in the community at least 14 days in advance for the board's adoption of a resolution to establish online voting. There are two other ones here. Unless the bylaws provide otherwise, written notice of any meeting at which a special assessment or an amendment to a rule regarding parcel use will be considered has to be mail delivered or electronically transmitted to all owners and conspicuously posted in the community at least 14 days before the meeting. So those are those three special times in which the board meeting notice will be kicked up from the basic 48-hour posted notice to a 14-day provided and posted notice. As with the membership, you do have some website posting requirements. You can't, if you're not required to have a website, you can choose to post your board meeting notice and agenda on the website, or if you have a downloadable application for at least the minimum period of time for which the notice is also to be physically posted in the community. So either 48 hours or 14-day. If you choose to use website for posting, again, this is not if you're required to do it. We'll talk about that in a minute. If you choose to do it and you're not required to do it, any rule that's adopted for posting notice on the website has to include a requirement that the association send out an email to the members who have provided their written consent to receive notice via electronic transmission that the notice is on the website. The notice has to include the hyperlink to the website or application on which that meeting notice is posted. Now, for our associations that are required to have a website, meaning an association that has 100 or more parcels, they must post the board meeting notice and agenda and any document that's required for the meeting on the association's website. So let's say that the board is adopting rules and regulations. Well, a copy of those proposed rules and regulations would need to be posted on the association's website together with the notice of the board meeting. All meetings of the board have to be open to all members except meetings between the board and its attorney with respect to proposed or pending litigation, where the contents of that meeting would be governed by the attorney-client privilege, or for meetings that are held for the purpose of discussing personnel matters. And personnel meaning employees of the association, not employees of the management company, right? Because that's personnel of your management company, and you guys hire your management as a vendor contractor with the association. So they're independent contractors, and the manager there is the personnel of the management company, not of the association. I get that question frequently enough that I thought I would bring it up here. Members have the right to attend all board meetings other than the ones that are supposed to be closed, and have the right to speak at any board meeting with reference to all designated items. Again, the association has the authority to adopt reasonable rules governing the frequency, duration, and other manner of those member statements, and I certainly suggest that they do so. There's no specified time minimum, but generally speaking, we would say the minimum of 3 minutes is probably reasonable to apply here. Same thing with membership meetings. An owner can tape record or videotape board meetings. And again, the board can and should adopt reasonable rules governing the taping of meetings. And if requested by someone who's physically handicapped has the right to attend the meeting, the board meeting has to be held at a location that's that's handicap accessible.
And take a water break. I need to address something that's coming up quite a bit, folks. The reasons your question may not be answered right away. I'm answering questions, and Courtney, we're answering questions that don't require the ESQ to be after our names. Okay. So, like somebody asked me, what is a member? I can answer that question because it doesn't require an attorney's interpretation of what a member of a homeowners association is. So, that's the reason why some questions are being answered and some are not right now. So, Danielle, back to you.
Sure. Compensation for our directors and officers. I know all of you are in it for the money, right? Pay is so great, actually. This
Bite
is
your
my
tongue. Bite
sarcasm.
your tongue.
Yeah, this is my sarcasm, folks. I know I can't see any of you, and you guys don't get to laugh at my jokes. I'll laugh at them later. A director, officer, or committee member. Thank you, Jeffrey. Thank you. May not directly receive any salary or compensation for performing their duties as a director, officer, or committee member, and they cannot in any other way benefit financially from their service to the association. However, there are certain times when they can receive compensation, like if they have paid some out-of-pocket expenses from their own money, they can be reimbursed for that. If the association has received insurance funds, and everybody is entitled to a portion of those insurance funds for whatever the damage may be, well, then they're able to get that just like any other member. They can also have compensation that's authorized in the governing documents or by a vote of majority of the voting interests in person or by proxy at a meeting of the members. And if you're developer controlled, the directors and officers who are appointed to the board or appointed as an officer can get paid for their job as an employee of the developer. So there is that caveat there as well. Kickbacks. An officer, director, or manager cannot solicit, offer to accept, or accept a kickback. And a kickback is anything of service, thing, or service of value, for which consideration's not been paid. And that's for the benefit of that person or for their immediate family members. And that whoever is paying the kickback is proposing to provide goods or services to the association. Anyone who knowingly violates this prohibition commits a third-degree felony and is subject to monetary damages. Again, criminal charges here applied to bad acts. An officer or director violating this prohibition is immediately removed from office by the board, which creates a vacancy that's then filled according to law, which could be, by the remaining board members, or if they decide by an election. until the end of term of office. However, we like to refer to this as the McDonald rule. An officer, director, or manager may accept food to be consumed at a business meeting with a value of less than $25 per individual. So don't expect whoever might be taking you to take you to Capitol Grill or something, because $25 these days doesn't go very far for a meal, but you can do that. And you can also receive goods or services in connection with trade fairs or education programs. So when you go to, like, say, one of the L&L expos that we go to throughout Florida, and you come to our booth and you get a piece of candy and a ruler or a stress ball, pens, feel free to take those because they're in connection with trade fairs or educational programs. Now, there are certain grounds which would immediately have you removed, and we did mention some of them earlier. A director or officer charged by information or indictment with any of the following crimes must be removed from office. So it's that forgery of a ballot or envelope or voting certificate used in an election, theft or embezzlement involving the association's funds or property, tampering with physical evidence, obstruction of justice. So these should sound a little familiar to you when we're talking about eligibility to be a candidate, or any criminal violation under the Homeowners Association Act. The board must fill the vacancy until the end of the period of suspension or until the end of the director's term of office, whichever is first. However, if the charges are resolved without a finding of guilt or without acceptance of a plea of guilty or nolo contendere meaning no contest, the director or officer must be reinstated for the remainder of their term. If the criminal charge is pending, then the person may not be appointed or elected to a position as an officer or director of any association and cannot have access to the official records of any association unless it's by a court order. That's what we were referencing before with regard to candidate eligibility. A director who becomes more than 90 days delinquent in the payment of any monetary obligation to the association is deemed to have abandoned their seat, creating a vacancy that's then filled according to law. So it's more than 90 days. It's not on the 90th day. It's on the 91st day. Now, sometimes there are scenarios where a director is like, oh, I have this landscaping company. I'd love for them to be able to give you a proposal, right? That presents a conflict of interest. That doesn't mean that you can't do it. However, there are certain disclosures and things that have to happen in order for the association to contract with that director's landscaping service, right? So directors and officers must disclose to the association any activity that may reasonably be construed as a conflict of interest at least 14 days before voting on an issue or entering in a contract that is the subject of a conflict. And there's a rebuttable presumption that a conflict of interest exists if any of these occur without prior disclosure to the association. A director or officer or relative of a director or officer enters into a contract for goods or services with the association, or they hold an interest in a corporation, LLC, partnership, LLP, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. So if we have these contracts in front of us, what do we need to do? So if the association enters into a contract or other transaction with one of its directors or a corporation or other entity, which the director is also a director or officer is financially interested, then the board has to do these following things. The proposed contract must be fully disclosed to the board and the disclosure entered into the minutes of the board meeting at which the contract will be considered and voted on, and it must be approved by 2/3 of the directors who are present. The contract or transaction with the director must be reasonable and fair to the association, and at the next members meeting, be it the annual or special meeting, the existence of the contract or transaction with the director must be disclosed to the membership. Now, the members can cancel that contract by a majority vote of the members present at the meeting. If the members hold the vote and the cancellation is approved, then the association is only liable for the reasonable value of goods and services provided up to the time of cancellation and is not going to be liable for any termination fee, liquidated damages, or other penalty that may be provided in the contract for cancellation. Now, delving into official records, what are our official records? Well, that contract that we entered into with the director, that would certainly be an official record. Copies of any plans, specifications, permits, warranties related to whatever improvements are constructed on the common areas or other property that the association is obligated to maintain. Maybe it maintains the median outside of its community according to a development order. Those items would be part of the official records. A copy of the association's governing documents, certainly, and amendments to those. The association must maintain an adequate number of copies of the recorded governing documents to ensure their availability to members and prospective members. What is considered an adequate number of copies is a great question. It really depends upon how many lots you guys have. So, you know, it's not an exact science, but if you only have like 50 lots in your community, maybe having on hand a few copies would be considered adequate. Minutes of all meetings, current roster of all members with their designated mailing address, lot identifications, and email address or facsimile numbers if they've consented to receive notice by electronic transmission and have not revoked that consent. Insurance policies, any contracts to which the association is a party, bids received by the association for work to be performed, financial and accounting records, including the accounts for each of your lot owners, whatever assessments have been levied and paid, tax returns, financial statements, financial reports, a copy of the disclosure summary in this particular statute, ballot sign-in sheets, anything used for voting. These have to be kept for at least 1 year after the date of the election, vote, or meeting. Affirmative acknowledgments, which has to do with invoices that are sent, and all other written records of the association that are not specifically identified. So really anything, any document or writing that has to do with the association is essentially going to be an official record of the association. Now, official records have to be maintained for at least 7 years unless the governing documents of the association require a longer period of time. Bids received by the association for work to be performed must be kept for 1 year. Again, the voting materials have to be kept for at least 1 year from the date of the vote. The association must adopt written rules governing the method or policy by which the official records of the association are to be maintained and for how long they must be maintained. This has to be made available to the owners through the association's website or application if you're required to have that website or application. So if you don't have any rules adopted yet governing how we keep our records and how long we have to keep our records, you need to do it immediately because it was effective law in July 1st of 2024. Now, notwithstanding, there are a lot of records that are considered official records of the association. Not all records are accessible to members for inspection and copying. Records protected by attorney-client or work product privilege relating to litigation, those are not going to be part of an inspection, a member's inspection of the official records. Information that's obtained in connection with the approval of a lease, sale, or other transfer of a parcel. So if your association does background checks on purchasers or tenants, those background checks would be confidential. Information obtained in a gated community in connection with guest visits to owners or residents. I sometimes think of this as like the mistress exception. Social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, facsimile numbers, emergency contact information, any other address that may have been provided unless it's been provided for notice purposes. The person's name, lot designation, mailing address, and property address, those are still part of the roster that is discoverable. The association's not liable for disclosure of protected information if the information is included in an official record and is voluntarily provided by the owner, not requested by the association. There are sometimes mistakes do happen, and it may be inadvertent. Personnel records of the association or management employees, medical records, and you may be thinking to yourself, like, when would I have medical records of an owner or resident? Well, let's think about, our emotional support animals, service animals, you would probably be in receipt of some medical records for that purpose. Any electronic security measure that's used by the association to safeguard data, and any association software and operating system which allows for the manipulation of data. So like Microsoft Word, even if the owner already has Microsoft Word, you can't share the association's version of it. And all of those affirmative acknowledgments, again, has having to do with sending invoices. This is a little information about what the attorney-client privilege is. Um, excuse me, that's provided by this particular statute. Correspondence from the lawyer remains privileged unless the board votes to waive the privilege. Only the board can vote to waive the attorney-client privilege. I cannot determine whether or not something is to be shared by an outside party. It's something that the board has to determine. As I had mentioned before, with regard to the personal identifying information, there are certain things that can still be disclosed. An association can print and distribute to owners a directory that has the name, lot address, and all phone numbers for each owner. However, an owner can exclude their phone number from the directory by requesting it in writing to the association. And the owner can also provide written consent to the disclosure of additional contact information that's not otherwise accessible to the members. As of July 1st of 2024, you must have provided a copy of your governing documents, articles of incorporation, bylaws. I would still have provided those even though they're not technically considered rules and covenants. I mean, this language is a little funny, but they're still part of your governing documents. And that complete copy must have been provided by October 1st of 2024. So hopefully you guys have already done that. It could have been a physical or a digital copy. You have to provide it to every single new member. And every time you amend them or change them, you do also have to provide an updated copy of everything. The association can adopt rules establishing standards for how they distribute and have a time frame for providing these rules and covenants. I will say that there's another section in the Florida statutes that pertains to amendments, and within 30 days of recording an amendment, having to provide a copy of the amendment, or if a copy of the amendment had already been provided, then at least providing notice of the official record book and page of that. And that has to be done within those 30 days of recording. I think it's reasonable to say 30 days of recording an amendment or adopting an amendment to your rules and regulations, because again, rules and regulations don't have to be recorded, would be a reasonable time frame. The association can comply with the requirement by posting a complete copy or a direct link to those copies on the homepage of the association website, so long as the website is accessible to the members and the association sends notice to the members that they are on the website either by email to those owners who have provided their written consent to receive notice via email, and by mail to those owners who have not provided their written consent to email notice, and it would be to the mailing address that's provided in the association's official records. Now, you've heard me mention inspection and copying of the official records. Well, how does that process happen? So unless otherwise provided by law or the governing documents, the official records must be made available for inspection and copying by an owner within 45 miles of the community or within the county, and within 10 business days after receipt of an owner's written request. In order to comply with this requirement, the association can have a physical copy of the records available for inspection or copying in the community, make them available electronically through the internet, or allow them to be viewed in electronic format on a computer and printed upon request. The advent of the website requirement has really helped a lot of associations once they make their documents, their official records, digital and post it on the website, because you can just direct your owner to the association's website to the extent that the records that they're looking for are posted there. So it makes it a lot easier. If the request is submitted by certified mail return receipt requested, then that creates a rebuttable presumption that the association willfully failed to comply if access to the official records not timely provided, meaning not provided within 10 business days after receipt of that written request. So you want to be sure that you are sticking to that 10 business day response requirement. An owner who is denied access to the official records is entitled to actual damages or minimum damages for the association's willful failure to comply. They're $50 per calendar day for up to 10 days, with the calculation beginning on the 10th business day. So you get, I'm sorry, with the 11th business day. So you get the 10 business days to comply. If you don't comply, well, the next business day is going to start racking up those minimum damages. If the association receives a subpoena for records from a law enforcement agency, then the association must provide a copy of those records or otherwise make them available for inspection and copying to the agency within 5 business days after receipt of the subpoena, unless it's otherwise provided by the agency or the subpoena. And the association must assist a law enforcement agency in their investigation to the extent permissible by law. Now, of course, with all of those fraudulent election voting crimes come these other official record crimes. Any director or manager who knowingly, willfully, and repeatedly meaning 2 or more violations in a 12-month period, if they fail to provide access to the official records with the intent of causing harm to the association or one or more of its members, that's a second-degree misdemeanor. A person who knowingly and intentionally defaces or destroys accounting records during the period in which records are required to be maintained, again, according to the rules that you need to have adopted, or who knowingly or intentionally fails to create or maintain accounting records that are required to be kept by the association with the intent of causing harm to the association or one or more of its members, commits a first-degree misdemeanor. So we're getting a little bit more serious here, and even more serious, any person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or assists another with doing so, commits a third-degree felony. So some serious stuff here. An association may and absolutely should adopt reasonable written rules governing the frequency, time, location, notice, records to be inspection, and manner of inspection. If you do not have these in place, I think they're just so important to have. An association cannot, though, require an owner to show any proper purpose for the inspection, to state any reason for the inspection, or limit the right to inspect records to less than 1 8-hour business day per month. So if you don't want to keep getting bombarded by official records requests, I strongly suggest that you adopt some rules regarding your official records requests, inspection, and copying. A member or their authorized representative is allowed to use a portable device, like your smartphone, to make an electronic copy of the official records free of charge. I have actually had, I mean, this is many years ago, but we've had an inspection here where somebody brought like one of those big printer scanners to the meeting and made all of their own scans and copies. I mean, they can totally do that. With the advent of these little things here, you know, the phones, it's a lot easier, but they can certainly do that. If the association has a copy machine available where the records are maintained, then it must provide the owners with copies on request during the inspection. If the copies to be made are no more than 25 pages, the association can charge up to 25 cents per page. If the association doesn't have a copier, or the copies requested exceed 25 pages in length, then the association can send those things out and have them made by a duplicating service and then charge the owner the actual cost of copying as supported by that vendor's invoice. The association can also charge for the costs required for personnel to get and copy records if the time spent in doing so exceeds a half hour, and if the personnel costs do not exceed $20 per hour. And the personnel costs cannot be charged for records requests that result in 25 or fewer pages. Now, as I mentioned before, with regard to the official records, having a website has been a lot of help for a lot of our associations. However, not all homeowners associations are required to have a website. Only those having 100 or more parcels must have a website, or they can have a downloadable mobile application. But for the most part, I see website as being more prevalent than the app. On that website or with that website, it has to be accessible through the internet, and it has to have some kind of subpage or a portal or other electronic location that's secured and accessible to the general public. That's only going to be accessible to owners and employees of the association. And owners are able to request from the association a username and password so that they can access those protected areas of the website. Now, on that website, the protected areas, you have to post a copy of all of these documents, all of the governing documents, your declaration of covenants, articles of incorporation, bylaws, amendments to them, your current rules, a list of all current executory contracts to which the association is a party or has an obligation, or the owners have an obligation. And after bidding of the related materials, equipment, or services has closed, then you need to have a list of the bids received by the association within the past year. The annual budget and any proposed budget to be considered at the annual meeting, the financial records, the financial report and any monthly income or expense statements that's considered at a meeting. The association's current insurance policies, all of the certificates that you will receive from today's class needs to be posted up there. Your certification stuff. Excuse me. All contracts on transactions that are potentially conflict of interest or with an officer, director, corporation, firm, which the officer, director may be a member or a officer, director, or financially interested. Again, notice of any board meeting and its agenda and any document that's required for that meeting, the membership meeting notices and any documents that might be required for those membership meetings. The notices for the membership meetings do have to be conspicuous on the web page or through a subpage where it says notices conspicuously on the homepage. The association has to ensure that whatever information and records which are not accessible to owners, again, we went through that list. We need to make sure that they're not posted on the association website or application. If a document is required to be posted, but it contains sensitive information, the information that's not accessible to owners, then we need to redact that information before that document gets posted on the website. However, the association or its authorization is not going to be liable for disclosing protected or restricted information unless that disclosure was made with a knowing or intentional disregard of the protected or restricted nature of that information. Again, inadvertent disclosure isn't going to attach a liability to it. Now, I've mentioned several times about amending your governing documents, but what does that really entail? Unless your governing documents provide otherwise, or unless otherwise required by law, governing documents can be amended by the affirmative vote of 2/3 of the total voting interest of your association. Amendments to the articles or bylaws that affect or impose a quorum or voting requirement greater than the general quorum or amendment vote requirement, they're not required to be approved by that greater number and can be adopted by whatever that lower threshold is. Amendments do have to be formatted in a particular way. Proposed amendments have to be shown in underline for new text and strikeout for old text. However, there are times when doing that would be so extensive, like if we're doing amend and restated governing documents, it would be so extensive that it would just make the document completely unreadable. In that case, we would have the statutory disclosure at the very beginning saying substantial rewording, see governing documents for current text. There are some times when documents will require mortgagee consent or lender consent. This particular section of the Florida statutes addresses that process. And if after 60 days there's no response, then the lender is deemed to have consented to the amendment. But your documents may or may not require lender consent. So that is a governing document specific issue. An amendment to the governing documents is effective when it's recorded in the public records, or more specifically the official records of the county in which the community is located. And as I mentioned before, within 30 days after recording an amendment to the governing documents, the association has to provide a copy of the amendment. However, if a copy was previously provided to the members and wasn't changed, then the association can provide notice to the members that it was adopted, that a copy is available, and also provide the official record book and page or instrument number of that recorded amendment. Even though this notice requirement is a requirement, it's like a no fault issue if you don't provide that notice. However, you do also have that other side of the statute, which does require that you provide them with updated information. So clearly, when they amended that into the governing doc, or excuse me, into Chapter 720 of the Florida statutes, they didn't take this part into consideration. So hopefully, um, when they decide to place their focus on the HOA Act, they'll tidy that up. So this one is like a little bit of a potpourri, this section. Things that were important to know, but didn't have enough to fill an entire section. So here we go with the litany of different things. Governmental filings. Yes, you do have to make some filings with the Division of Corporations. Again, vast majority of our associations are Chapter 617 Florida Not-for-Profit Corporations. So you do have to file an annual report with the Division of Corporations. Annual income taxes, you do still have to file for your annual tax return. Um, you may or may not have any kind of tax implications. You know, assessments usually everything evens out. What comes in goes out for the association. So, obviously refer to your tax professional for that advice. Our membership meetings, you do have to have minutes. I'm sorry, meeting minutes. We do have to have minutes for all of our meetings, whether it be a membership meeting or a board meeting. They don't have to be verbatim records. You don't have to put Johnny said this, Tammy said that, Michael said this. It does not have to be verbatim that way. You can just have a general statement like saying that this was discussed by the board members. But you certainly want to have in there whatever the motions are made, whoever seconded the motion, and then that discussion was had, opened up for the members to comment, and then brought back to the board, and however the director voted for our board meeting minutes. It's very important that you do have a vote or abstention from voting for each matter voted on by the directors at a board meeting. Material alterations. This is something we mentioned briefly at the very beginning. A material alteration is essentially anything that palpably or perceptibly varies or changes the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function or use or appearance. Well, that is a long definition from a case, a condominium case. Basically, any type of change could be considered a material alteration. Generally speaking, homeowners associations, boards can make decisions about material alterations to the common areas. However, you want to look at your governing documents because your governing documents might have some kind of membership approval requirement. And sometimes it's tied to like the expense. Excuse me, if the project's going to cost X dollars, more than X dollars, or more than X percentage of the association's annual budget, then it would require some kind of level of membership approval. Again, governing documents specific. So look at your governing documents, usually in the declaration. Our rules and regulations. So we have our declaration, articles of incorporation, bylaws, and our rules and regulations fall at the very end. The association can promulgate rules and regulations. They must be reasonable pertaining to the use of the common areas, whether it be recreational facilities, what have you, and the lots, if the governing documents don't provide. So this authority is going to be something that's provided in your governing documents. Usually rules and regulations are adopted by the board. However, sometimes governing documents do require membership approval of board adopted rules before they become effective. So check your governing documents. Just a reminder here, when the board is adopting rules regarding parcel use, it does have to be provided to the members at least 14 days before the meeting and posted in a conspicuous place in the community at least 14 days before the meeting. Written notice of a board meeting for any other rules is that normal, typical 14 hours posted, conspicuously posted in the community before the board meeting. Now, the Marketable Record Title Act. Some of you may have, if you have an older community, may have already heard about the Marketable Record Title Act in the most general sense possible because it is quite complicated. The declaration of covenants begins to automatically expire on a lot by lot basis 30 years after the original recording of the declaration. And there are a few exceptions to that, though it's difficult to find in real life. At the first board meeting following the annual meeting, so not your organizational meeting though, the board meeting that you have after you have your organizational meeting, the board is required to consider filing a notice to preserve the covenants from the effects of MARTA and to authorize and direct the appropriate officers to file that preservation of covenants. So even if you're in year, 5, 6, 7, 8, you still have to consider preservation of the covenants every single year. Covenant preservation can be done in one of three ways: by a written notice pursuant to this statute, by summary notice pursuant to this other statute, or by amendment to the declaration, which references the recording of the original declaration. These three options are obviously all viable. We typically use the summary notice option because it is the easiest and simplest one to get done. Once you record your covenant preservation notice, it has the effect of continuing the effectiveness of those covenants for an additional 30 years. If you happen to pass that 30-year mark from the recording of the original declaration, you may or may not have become subject to extinguishment under the Marketable Record Title Act. There is an analysis that has to be taken in order to determine whether or not it has affected any of your lots. But generally speaking, we use that 30-year mark to say, okay, after that mark, if you have not preserved your covenants, now you have to go through revitalization. And revitalization is a time-consuming and expensive process. The board has to appoint an organizing committee. The organizing committee puts all the documents together. Everything gets sent out to the membership. Majority membership approval if it's required. And I'm speaking very generally. And then once everything's been approved, then a package has to be prepared and sent up to the Florida Commerce, which is I think the Department of the Treasury for Florida, and approved by them, and then sent back to us and then record. I mean, it's a whole process, takes a long time. So you certainly want to be putting on your calendar every year at that board meeting the consideration of covenant preservation. For our emergency powers, unless your governing documents prohibit this, the board can exercise emergency powers in response to a declared state of emergency. These emergency powers are only available to the board for the period of time that's reasonably necessary to protect the health, safety, and welfare of the association and the owners, their family members, tenants, guests, agents, and invitees, and to mitigate further damage, injury, or contagion and make emergency repairs. Contagion never used to be there. That was put in after the whole COVID mess. These emergency powers include to conduct meetings by telephone, video conferencing, or other real-time electronic or video communication after they provide notice in as practicable a manner as possible. Notice of decisions can also be communicated in one of these different manners here. They can cancel and reschedule meetings, designate assistant officers who are not directors, which will step into the shoes of an officer in the event there's an incapacitation or unavailability of an existing officer, relocate or designate an alternative principal office, enter into agreements with counties and municipalities to assist them with debris removal. They can have a disaster or emergency plan and determine any portion of the common areas to be unavailable for entry by owners or their family members, tenants, guests, or agents to protect health, safety, or welfare based on the advice of emergency management officials, public health officials, or licensed professionals that are retained or otherwise available to the board. So maybe you have, you had a hurricane or a tornado come through, it's damaged the roof of the clubhouse, and it's not safe for people to go into. So you could, close that portion off under these emergency powers. You could do things to mitigate other damages, further damages, levy special assessment without a vote of the members if it's otherwise required by your governing documents, and without the owner's approval, borrow money and pledge association assets as collateral to fund emergency repairs and carry out the duties of the association if their operating funds are deficient. And this is in addition to the association's general authority to borrow money that might be provided in the governing documents. Although the association's board has these emergency powers, the association cannot prohibit owners, tenants, guests, agents, or invitees of an owner from accessing the common areas and facilities for the purpose of ingress and egress to and from the parcel when necessary in connection with the sale, lease, or other transfer of a parcel, or dealing with habitability of the parcel, or for the health, safety of such person, unless there's a government order to the contrary. Debit cards. So obviously the association has a bank account. And usually with a bank account comes debit cards, but an association and its officers, directors, and employees and agents cannot use a debit card that's issued in the name of the association or billed directly to the association for the payment of any association expenses. So that's the general rule. But now let's talk about when things aren't so neat and tidy, right? A person who uses a debit card that's issued in the name of the association or billed directly to the association for an expense that is not a lawful obligation of the association commits a theft. Kind of sounds like, well, you can use a debit card, but only if it's for the lawful obligation of the association. Otherwise, it's considered theft, right? So kind of a little bit of a head scratcher there, right? The term lawful obligation of the association means an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or written budget. So generally speaking, just to be safe, don't use debit cards that are in the association's name or billed directly to the association. Get a credit card. That can be done. Litigation authority. So the association can sue or settle or appeal actions, litigation in its name on behalf of all members concerning matters of common interest, which can be matters regarding the common areas, roof or structural components of a building, other improvements, representations of the developer pertaining to any existing or proposed common use facility, protesting ad valorem taxes on commonly used facilities, and defending an eminent domain lawsuit and bringing an inverse condemnation claim. Now, for associations that want to commence a litigation against a party in the name of the association that involves amount in controversy in excess of $100,000, the association must first obtain the affirmative approval of a majority of the voting interests at a meeting of the members at which a quorum has been obtained before it can actually sue. So architectural control. I feel like architectural control is actually one of the main reasons why associations are created, other than for maintenance of infrastructure. You have the obligation to maintain the roads and whatever facilities that you have, but this is like the second most important tenet of a homeowners association. So an association must reasonably and equitably apply and enforce its architectural and construction improvement standards, or whatever other published guidelines and standards they have that are authorized by the declaration. If the association denies an owner's request or application, then the association must provide written notice to the owner stating with specificity the rule or covenant on which the association relied when denying the request, and the specific aspect or part of that proposed improvement that does not conform with such rule or covenant. The association cannot enforce or adopt a covenant, rule, or guideline that would limit or place requirements on the interior of the structure that's not visible either from the lot frontage, adjacent parcel, adjacent common area, or community golf course. That requires the review and approval of plans of specifications for central air conditioning, refrigeration, heating, or ventilation system by the association if the system's not visible from the frontage, an adjacent parcel, an adjacent common area of a golf course, and is substantially similar to a system that is approved or recommended by the association. So basically, if you can't see it, it doesn't matter to the association. And if it's referring to the Floridians keeping their air conditioning, you know what? They're going to be able to do that too. Regardless of what may be in your governing documents, and it's unless it's prohibited by general law or local ordinance, the association cannot restrict owners or their tenants from installing, displaying, or storing any items on a parcel which are not visible from the frontage or an adjacent parcel, an adjacent common area, or community golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. Again, this is legislature clearly saying to homeowner associations, if you can't see it, if no one can see it, you don't have any authority over it. For our hurricane protection, now this is very interesting for homeowners associations because in condominium associations, we've had hurricane protection or at least hurricane shutter provisions in the statute. Now this is fairly new for homeowners associations. The association must adopt hurricane protection specifications for each structure or other improvement on a parcel that's governed by the association. And hurricane protection can include roofing systems, storm shutters, roll down shutters, impact resistant windows and doors, reinforced garage doors, a lot of things, fuel storage tanks, any hurricane protection product used to preserve and protect structures or improvements on that parcel. The specifications must comply with applicable building code and may include the color and style of hurricane protection products and any other factor that's deemed relevant by the board. The association cannot deny an application for the installation, enhancement, or replacement of hurricane protection, which conforms to those specifications that are adopted by the board. And the association may require that an owner adhere to an existing unified building scheme regarding the external appearance of the structure or other improvement of the parcel. So, let's say you have like a Mediterranean scheme and everybody's got roll down shutters of a terracotta color, something like that. For our vehicle restrictions, the association's governing documents cannot prohibit an owner, tenant, guest, or invitee from parking their personal vehicle, which would include a pickup truck, in the owner's driveway or in any other area which the owner, tenant, guest, invitee has a right to park as governed by state, county, and municipal regulations. An owner, tenant, guest, or invitee from parking their work vehicle, regardless of any official insignia or visible designation, which is not a commercial motor vehicle as defined in this particular statute, in the owner's driveway, and cannot prohibit operating a vehicle that is not a commercial motor vehicle in conformance with state traffic laws on public roads or rights of way or the owner's parcel. So I remember when this first came out and all the, pickup truck drivers were very excited by this because they would say, our documents have prohibited pickup trucks forever and ever. And now they can't enforce that anymore. Well, no, that's not necessarily true because this is a substantive change, right? At least from our perspective, it's a substantive change. And you really need to be looking at whether or not your association has common language. So, this is something that you definitely, if you're having an issue in your community pertaining to pickup trucks and you have owners using this law as their defense, as their sword, you may want to get an opinion from your association's legal counsel. Contractor restrictions, an association's governing documents cannot prohibit an owner from having a contractor come in to work on the owner's parcel simply because that contractor is not on the association's preferred vendors list, and cannot prohibit an owner from having a contractor come in on their parcel simply because the contractor does not have a professional or occupational license. And the association cannot require that the contractor present or prove possession of that license to be allowed to get into the community. Budgets and reserves. So every year we got to adopt a budget, right? The association has to prepare an annual budget that reflects the estimated revenues and expenses for the upcoming fiscal year. And the fiscal year typically is the calendar year, though you do want to look at your governing documents to make sure that that is the case. Could be different. A lot of times the fiscal year is going to appear in your bylaws, but it could be in your other governing documents. The budget also has to reflect the estimated surplus or deficit as of the end of the current fiscal year. So you're carrying forward whether your surplus or deficit may be, and then line iteming all of your other estimated expense items so that you can determine what your assessments are going to be for the following year. The budget must set out separately all fees or charge paid for the association for recreational amenities, the developer, whether owned by the association, the developer, or any other person. So if you have recreational amenities, you do have to set forth what other fees or charges have to be paid for them. And generally speaking, your budget includes two main components: operating expenses or reserves, if you have reserves established. And when creating your budget, use last year's actual expenses to plan for next year's budget. And money's in the operating section of the budget. Although you have line items that say, okay, this amount for this amount for this, they're not restricted to those particular purposes. So let's say you spent $5,000 less in legal for the year, but you had all these different maintenance things that you had to deal with. Well, you can use whatever the overage is in one area and apply it to another one. These dollar bills are not restricted for use like they would be in a reserve. So let's talk more about reserves in a minute. So our operating expenses, these are the expenses for our day-to-day operation of the association. They're listed by account and classification and should project the total proposed annual expenditures for that particular classification, like landscape maintenance, management fees, if you have a pool, whatever the pool maintenance is. And so there are some other here, your insurance premiums, whatever your legal budget is for the year, and reserves. So not every single homeowners association has reserves. Your budget may include reserve accounts for capital expenditures and deferred maintenance. A capital expenditure is any expenditure of funds for the purchase or replacement of an asset that puts its useful life at greater than 1 year. Excuse me. Deferred maintenance is any maintenance or repair that will be performed less frequently than yearly and results in maintaining the useful life of that asset. And some examples include, repaving all of your roads, certain repairs or improvements to the common areas, sidewalk improvements. And reserves are really particular. I know a lot of people use the term reserves, but they're really referring to a discretionary savings account. Any reserve that's created without the affirmative approval of a majority of the total voting interests of the association isn't a true reserve. It's just a slush fund discretionary savings account. Once the association's membership has approved that reserve, then the board must include that reserve account in the budget for the next fiscal year and for every single following fiscal year. It has to be funded and maintained or waived in the manner provided by Florida statutes, and there is a particular manner in which it's calculated. So the amount to be reserved is based on the estimated remaining useful life of that item and its estimated replacement cost or deferred maintenance expense for each reserve item. And that's what gets allocated year per year. The association can certainly adjust whatever those amounts are to take into account any changes in the estimates. Maybe materials become more expensive and they account for that as well. Unless the association maintains a pooled account of reserves, the reserve schedule should include each reserve account as a separate line item with the following minimum disclosures: the total estimated useful life of the asset, estimated remaining useful life of the asset, estimated replacement cost or deferred maintenance expense of the asset, and the estimated fund balance as of the beginning of the period for which the budget will be in effect. So whatever reserve amounts have been accrued up to the date of the next fiscal year. Now, using reserves for other purposes. If you have a true reserve, those funds can only be spent on the reserve item unless their use for another purpose is approved in advance by a majority vote of the members at a meeting at which a quorum is present. So if you have a true reserve, you need to be spending it on those reserve items unless you get this vote. Now, the association can also establish a pooled reserve instead of doing individual line items. If the association establishes a pooled reserve account for two or more reserve funds or reserve items, the funds can be drawn from this account, but only for those particular items within the pool. If you want to use it for other items that are not within that reserve pool, you would still need to get that membership vote. The difference between those individual line items and a pooled account is that instead of each reserve account having its own fund balance, you have a pooled amount of funds that can be drawn on at different times for those different items. So generally speaking, if you have that pooled reserve, the reserve funding requirement is a little bit lower than with individual line items. Waiving, reducing, and terminating reserves, similar to using reserve funds for different purposes. If you're going to waive or reduce your reserves, you have to get majority voting interests to approve it at a membership meeting. Otherwise, you're going to be fully funding those reserves. Again, these are only for true reserves. The vote to waive or partially fund reserves is only applicable for that budget year. And whether to submit the vote to the members is something that's decided on by the board. It's certainly not required by law. Reserve accounts that are established by membership vote can be terminated by vote, but this time it's by vote of a majority of the total voting interest of the association. And once it's been approved, then those terminated reserve accounts must be removed from the budget. Now, for noticing and adopting that budget, let's say we've got our budget together, it's got our operating expenses, it's got our reserve expenses. What do we do with it now? So the governing documents have to be looked at to see if you have any particular budget meeting notice and adoption requirements. Not all associations are the same for this. Some of them will require that it be a copy of the proposed budget be sent to the members. Some of them are silent. If your governing documents are silent, then the notice of the board meeting at which the proposed budget will be considered and adopted has to be conspicuously posted in the community at least 14 or 48 hours in advance of the meeting. So it's just a regular 48-hour posted notice requirement unless your governing documents require otherwise. Unless your governing documents require the board to provide a copy of that proposed budget to the owners before the board meeting at which it will be adopted, there's no requirement to do so by law, but we do suggest that you consider sending it to your members. Once the budget's been adopted, then the association must provide each member with a copy of that budget or with written notice that a copy of the budget is available upon request at no charge to the member. If the copy is requested, then you would be providing it to the member within 10 business days after receipt of that written request. An association with 100 or more parcels must post a copy of the annual budget on its website. And that goes back to those website posting requirements that we discussed earlier. Now that we've adopted our budget, that is an assessment, right? So once we adopt our budget, we've adopted our regular or general assessments for that fiscal year. Well, sometimes we have need to assess for other things. Maybe there's an unexpected replacement. Our pool pump has died and we need to get a new pool pump to keep our pool clean and safe for our members and their families to swim in. Written notice of any board meeting at which a special assessment will be considered must be mailed, delivered, or electronically transmitted to the members and conspicuously posted on the property at least 14 days before the meeting. With this notice, you do have to include a statement that a special assessment will be considered and the nature of the assessment, and you should identify the estimated cost of the assessment. Once that's levied, the association should send written notice to the owners that a special assessment's been levied and provide them with a reasonable period of time to pay for it. The special assessment that's not been paid by an owner can be collected in the same manner as a general assessment by lien and foreclosure process. Now, this is assuming that your special assessments are leviable by the board. which generally speaking, there's nothing in the statute which requires that assessments, special assessments be levied by membership approval. Sometimes governing documents do require this though. So look at your governing documents to see if membership approval is required for levying your special assessments. A parcel owner can make a written request to the board for detailed accounting of any amounts they may owe to the association that's related to their lot, and the board must provide that information within 15 business days after receipt of that written request. Once they make that request, they can't make another request for at least 90 calendar days. And the failure of the board to respond within that 15 business day period constitutes a complete waiver of any outstanding fines of the person who requested such accounting, which are more than 30 days past due, and for which the association has not given prior written notice of the imposition of the fines. So even though the accounting is with regard to any monetary obligation due to the association, the failure here within that 15-day period is only with regard to the fine. That waiver is only with regard to fines. For a collection of assessments, interest accrues according to the governing documents, but if there's no rate provided in your governing documents, then it's 18% per year. You cannot compound interest. You would be charging it, what is it, 1.5% per month. It's that 18% per year. Administrative late fees not to exceed the greater of, excuse me, $25 or 5% of the amount of each delinquent installment can be imposed if permitted by the declaration or the bylaws. However, do not charge interest or on late fees. And attorney's fees and costs, the association is entitled to collect those attorney's fees and costs that are incurred in collection of any delinquent assessments. It says, but see notice of late assessments here because there is a small caveat to that, and we'll get to it in a moment. Let's say that there is a delinquency and there have been interest that's been accrued. Maybe there are some attorney's fees, but the owner makes a payment. Well, that payment, once it's received by the association, is first applied to any interest that's accrued by the association, then to the administrative late fee, maybe it's that $25 or 5% of the delinquent installment, then to any costs and reasonable attorney's fees that were incurred in collection, then finally to the delinquent assessment. Now to that notice of late assessment. Generally speaking, when we're looking at the foreclosure timeline, we have the 30-day notice of late assessment, then we have a 45-day notice of intent to file a claim of lien. Then we file the claim of lien. Then we have another 45-day notice with the intent to foreclose before we actually get to that foreclosure period. Now, the notice of late assessment provides the owner with a 30-day period within which they can bring their account current before attorney's fees can be attached and charged. So generally speaking, this notice of late assessment will be sent by the association, either by the board, its bookkeeper, or its management company, and not by the association's attorney, because the attorney's fees won't be attachable if they make the payment under the notice of late assessment, right? Once you send out the notice of late assessment, you're going to want to have the person who sent it out to sign an affidavit that they did so. Excuse me, that attests to them having sent the notice of late assessment. Generally speaking, if they don't pay within that 30-day period after the note of late assessment, then they're going to be, usually turning it over to the association's counsel for the 45-day notice of intent to file a claim of lien. So you send out that 45-day notice of the intent to file a claim of lien. Let's say they don't pay, then you file that claim of lien in the official records of the county, and you issue that notice of intent to foreclose. Again, that notice of intent to foreclose is a 45-day notice. Let's say they don't pay, still don't pay within that 45-day notice, then you can file your foreclosure action. For our first mortgagee assessment liability, you may have heard the term safe harbor. So if there's a first mortgagee or a successor and assignee of that mortgagee that forecloses their loan against the lot and they take title to that lot by foreclosure, by deed in lieu foreclosure, they get special protections for whatever assessments may be due to the association upon obtaining title. And it's going to be the lesser of the lot's unpaid common expenses and regular periodic special assessments that accrued during the 12 months immediately before they get that title, for which payment has not been made in full, or 1% of the original mortgage debt. So whichever is less. The limitations on first mortgagee liability apply only if the first mortgagee initially joined the association as a defendant. I would say that if you have a lender's foreclosure attorney who fails to name the association, I mean, I would hate to be that person. But they do have to name you in that initial pleading. Now, sometimes the property will go to bidding, and there will be somebody else there who purchases the property. So a third-party bidder on a foreclosure property has joint and several liability for any past due assessments. However, if the association forecloses and acquires title, and then the lender forecloses its interest, the third-party bidder is not going to be liable for assessments accruing during the time that the association owned the property, right? Because it's essentially the association like paying itself, right? So for the time the association owned the property, they're not going to be accruing assessment liability for that. Since we're on the theme of money, our financial reporting. So each year the board has to prepare or have completed with a third party, which is very typical. I wouldn't suggest the board do this on their own. A financial report of the financial activities for the preceding fiscal year within 90 days after the end of the fiscal year, or annually on whatever date might be provided in your bylaws. Again, check your bylaws. Usually it's the bylaws where your fiscal year is provided, but it's typically the calendar year. Within 21 days after that financial report is completed or received from your accountant, but not later than 120 days after the end of the fiscal year or whatever date may be provided in your bylaws, the board must provide each member with a copy of that financial report or written notice that a copy of the financial report is available upon request at no charge to the member. Now, what level of financial reporting is required for your association? If you have less than $150,000 in total revenue, you're preparing a report of cash receipts and expenditures. Between 150 and 300,000, you're preparing compiled financial statements. 300,000, but less than 500,000, you're preparing reviewed financial statements, and $500,000 or more, you're preparing full-blown audited financial statements. Even if you don't fall within that $500,000 or more in total revenue, if you have at least 1,000 parcels, you do have to prepare an audited financial statement. If 20% of the owners petition the board for a level of financial reporting that's higher than what's required based upon their total revenues, then the association must notice and hold a meeting of the members within 30 days of written receipt of that petition for the purpose of voting to raise the level of reporting, financial reporting for that particular fiscal year. If it's approved by a majority of the total voting interest, then the association must prepare or cost to be prepared again by that third party, whatever level, higher level is voted upon by the members. A copy of the financial statements, a copy of the financial report must be provided to the members within 90 days of the meeting or the end of the fiscal year, whichever occurs later. The board must amend the budget or adopt a special assessment to pay for whatever costs may be incurred in raising that reporting level without any kind of membership approval if it may be required by the governing documents. Now, if it's approved by a majority of the voting interests present at a properly called meeting of the association can prepare or cause to be prepared a lower level of reporting requirement than whatever may be dictated by your total receipts. The association may not prepare a financial statement at a low reporting level for consecutive fiscal years. So if you've lowered it one year, the next year you're going to be preparing the financial statement that's required based upon your level of total revenues. Now, if your budget does not provide for reserves or the governing documents don't obligate the developer to create reserves or statutory reserves are not fully funded, Then your financial report has to have this first disclosure. If the budget does not provide for statutory reserves but includes discretionary reserves, then the budget has to include this particular, I'm sorry, your financial report has to include this particular disclosure. And this is something that whoever's preparing these documents for you should be able to, should know to include. Now, contracts. Although I certainly advise that all contracts be in writing, not all of them must be in writing. Um, though it must be in writing if the contract cannot be fully performed within 1 year, excuse me, 1 year for the purchase or lease of materials or equipment, and if it's a service type contract. Again, really, you should have all of your contracts in writing. Let's say something goes wrong and you need to fix something. You're going to have a really, really tough time trying to do that if you don't have a written contract. All written contracts entered into by the association for the operation, maintenance, or management of the association or property serving the owners should specify, okay, what are the obligations of the parties? How much are we going to pay? How often are they going to perform those services? And how many people are they going to have performing those services? So for our bidding, you heard me mention that bids are required, official records required to be maintained as official records of the association, and a list of those bids must be posted on the association's website. So let's talk a little bit about bidding. If the aggregate cost of the contract is more than 10% of the total budget, including reserves, then the association must obtain competitive bids for those materials, equipment, or services. Now, there's no requirement as to how many bids they have to obtain, but they do need to get bids. The association's not required to accept the lowest bid. The association is not required to obtain competitive bids for products and services in emergency circumstances, or if the contractor is the only provider within their area for that item. Contracts that are executed before October 1st of 2024, or I'm sorry, 2004, which is a very long time ago at this point, and any renewal thereof are not subject to the competitive bid requirements. I don't know what contract that might be. Maybe a bulk services contract that's been there forever and ever. Bidding, the following contracts are exempt from the bidding requirements: associations, employees, the attorney, accountant, architect, manager, though if it's done by competitive bid, can be made up for 3 years. An engineer and a landscape architect. However, again, these contracts must be in writing. Estoppel certificate. So within 10 business days of receiving a written or electronic request for an estoppel certificate from an owner or mortgagee or either of their designees, the association must issue an estoppel certificate. The estoppel certificate format is provided by statute. So it has the different types of information that have to be provided on the estoppel. The association has to designate on its website a person or entity with a street or email address for the receipt of these requests. The estoppel certificates have to be completed by a director, authorized agent, or representative of the association, and that could include someone from the management company. They have to be provided by hand delivery, regular mail, or email on the date of issuance. So the date that it's signed is the date that it needs to be delivered. Estoppel certificates must be signed by an officer or authorized agent of the association. And as I mentioned, the form is provided by statute with all the different types of information that needs to be provided. So general, and I think there's like 3 categories: general information, name of the owner, designation of their address, the attorney's name and contact information if there's a delinquency that's been turned over to the association, a name of the requesting party, the fee that's charged, and we'll talk more about fees. Whatever the assessment information is, how much are assessments? When are they due? Are there any assessments due for this lot? What assessments are coming up? Other information is the 3rd category here. Is there a capital contribution fee? That's something that's going to be provided by your declaration if you have one, a resale fee, a transfer fee, other fees. Maybe your association does screening and approval of sales and leases in your community. That's something that you would be providing here. And interestingly, right of first refusal, that's another thing that's going to be in your governing documents. But what I like here is whether or not there's an open violation of a rule or regulation. So, like for example, when I purchased my home, the mailbox was broken, the driveway needed to be cleaned, and all of these things were provided on the estoppel certificate. So I think that's actually been a good development for homeowners associations here, so that they know that there are violations existing at this property that need to be repaired. Um, Now, when it comes to charging the fee for the estoppel certificate, a reasonable fee not exceeding $250 can be charged if on the date the certificate is issued, there's no delinquency owed to the association. If there is a delinquency, then you can add an additional $150. And if they ask for an expedited estoppel certificate, meaning delivered within 3 business days after the request, then you can charge an additional $100. To charge that estoppel fee, the authority to do so has to be established by either a written resolution adopted by the board or as provided in a written management, bookkeeping, or maintenance contract. And a lot of times you do find this in the management contracts. If the association fails to deliver that estoppel certificate within the 10 business day deadline, the fee cannot be charged, and you really don't want to be missing that deadline. If the certificate is requested in conjunction with a sale or mortgage of the property, but a closing does not occur, and within 30 days after the closing date, the preparer receives a written request accompanied by a reasonable documentation about the cancellation, then the fee has to be refunded to the payor within 30 days after receipt of a request. However, that's an obligation of the owner, not of the association. Estoppel certificates delivered by hand or by email are effective for 30 days. Estoppel certificates that are delivered by mail are effective for 35 days. I guess they bump in 5 days to account for the delay in mailing. If additional information or mistake is noticed on the estoppel certificate, then the association has to issue an amended estoppel certificate, and it becomes effective. And becomes effective if a sale or refinancing the parcel has not been completed during that effective period. A fee cannot be charged for that amended estoppel certificate, and they get a new 30 or 35-day effective period, depending upon how the amended estoppel certificate is provided. Now, this is very important. An association waives the right to collect any monies owed in excess of the amounts specified in the estoppel certificate from any person who in good faith relies upon the estoppel certificate and from the person's successors and assigns. So you'll want to make sure that the amounts that you're providing on the estoppel certificate are correct. Otherwise, you could be losing out on funds. Covenant enforcement. This is another topic that usually gets a lot of attention, and we do have a class that's dedicated specifically to covenant enforcement. The association is charged with the responsibility for uniformly enforcing its governing documents. Uniformly is bolded there because it has to deal with the owner's most favorite defense of selective enforcement. Specific covenants and restrictions that the board is responsible for enforcing can include those architectural standards, pet leasing and parking restrictions, nuisance conduct, what have you. The failure of the association to enforce covenants and regulations in a timely manner could result in a waiver or forfeiture of enforcement rights. Another couple of defenses there that can be raised by owners. Generally speaking, the first step in enforcement should be to provide the owner with a notice of the violation from the association. That notice should include a statement of the violation, what was violated, and how they can cure that violation if it is something that's subject to cure, like cleaning the roof or driveway. If voluntary compliance is not achieved, like the owner doesn't listen to the letter that they received, then we jump to additional enforcement measures like fining, suspension of use rights, suspension of voting rights, self-help if it's authorized by governing documents, mandatory pre-suit mediation, and litigation. And now let's jump into those specific things. So the levy of fines and use right suspensions is available for everything but failing to pay monetary obligations. A fine, you won't have the ability to issue a fine for failure to pay monetary obligations. You will have that ability for use right suspensions and voting rights suspensions. And voting rights suspensions you cannot do for any type of non-monetary violation, as you'll see here. So the association has the authority to fine and suspend use rights of an owner or their tenant, guest, or invitee for failure to comply with the governing documents. And again, we're not talking about monetary obligations here. We're talking about the cleaning the driveway, cleaning the roof, parking violations, things of that nature. A fine or use right suspension cannot be imposed unless first the board levies the fine or use right suspension at a properly noticed board meeting. Once it's been levied by the board, then they provide the violating party with 14 days written notice of the hearing on the alleged violation. And that notice has to provide a description of the alleged violation, whatever action is needed to cure that violation if it's subject to cure, and the date and location of the hearing and access information if that hearing is going to be held by telephone or other means. The hearing must be held within 90 days after issuance of that hearing notice before a committee of at least 3 members who are appointed by the board and are not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. Now, the role of that committee is limited to determining by a majority vote whether to confirm or reject the fine or use right suspension as it is levied by the board. If they do anything other than confirm that fine or suspension as it's levied by the board, it's not going to be imposed. You're going to have to start the process over again. The committee can hold that hearing by telephone or the electronic means, and the owners have the right to attend that hearing by telephone or electronic means, which is why you have to put that access information into that hearing notice. Within 7 days after that hearing, the committee must mail or email written notice to the violating party of their findings related to the violation and any applicable fines or suspensions that the committee approved or rejected, how the violation can be cured if it's something that's subject to cure, and the date by which the fine must be paid. Now, when it comes to the date of the fine must be paid, the committee has to be a little bit clairvoyant here. The committee, because they have to set the date, and the date has to be at least 30 days after delivery of the notice of the committee's findings. So they need to account for whatever delay may be taken in actually getting that letter done, and then adding on time for mailing or if unless they're going to send it by email. So you need to have a little bit of a crystal ball here and add in some additional time. Now, if the violation has been cured before the hearing or in the manner specified in the hearing notice or in the committee's notice of the committee's findings, then the fine cannot be imposed. Just note that here, the attorney's fees and costs cannot be awarded against an owner based on actions taken by the board before the date set for the fine to be paid. So if you want to be tracking down that fine, you're going to wait until that 30-day that 30-day fine payment period has ended. If a violation and the fine levied by the board is approved by the committee and the violation is not cured or the fine's not paid, then reasonable attorney's fees and costs can be awarded to the association. The fine itself cannot exceed $100 per violation unless otherwise provided in the governing documents, and it cannot exceed $1,000 per violation in the aggregate unless otherwise provided in the governing documents. Now, if the fine reaches $1,000 or more, then it can become a lien against the lot and collected through the lien foreclosure process, just like an assessment if the authority to do so is provided in that declaration. With our use rights suspension, the suspension affects the common areas and facilities, but it does not apply to those portions that are used to provide access or utility services to the lot, and can't prohibit the owner, resident, tenant from having their car there or the right to park, the ability to drive in and out of the community from the lot or to or from the lot. And the suspension applies to a member and, when appropriate, their tenants, guests, or invitees, even if the violation resulting in the suspension arose from less than the multiple lots owned by a member. So if there's a member who owns multiple lots, the violation existed as to one lot, and that's what the use rights suspension was levied for, it's going to apply to all the other lots as well. Notwithstanding any provision to the contrary in your governing documents, the HOA cannot levy a fine for leaving your garbage receptacle at the curb or the end of the driveway within 24 hours before or after the designated garbage collection time, or leaving holiday decorations or lights on a structure or other improvement longer than what's permitted by the governing documents, unless they've been left up for longer than 1 week after the association provides written notice of the violation to the owner. So a lot of boards will see this and be like, oh my gosh, then why even bother having the rules here? Well, you still can enforce those rules about the garbage bins and when they can be out and brought back in, and about leaving the holiday decorations up for a permitted amount of time. However, these are just additional procedural measures that you have to take if you intend to fine or levy use right suspensions for these particular violations. Okay, so as I mentioned before, use right suspensions, they're kind of like, the AB of the blood types here. They can be used for both failure to pay monetary obligations and for other violations of the governing documents. Now, when it comes to monetary obligations, that delinquency has to be greater than 90 days delinquent to the association. That's not on the 90th day, that's on the 91st day. Now, if they have that delinquency on that 91st day, the board can suspend their use rights at a board meeting. You go to the board meeting, you suspend the use rights, then you send written notice of the suspension, either by mail, hand delivery, or email. Again, email requiring written consent to the owner, and if it's applicable, to their occupant licensee invitee. The suspension of the right to use those common areas, similar to the other one, does not apply to those common areas that are required for ingress, egress, to and from the lot, or for utility purposes and for the ability to park their car. The suspension applies to the member, and again, when appropriate, all of the other tenants, guests, invitees of the multiple lots that are owned by that member, and the suspension will end upon full payment of that delinquency. Similar right exists for voting suspensions, though you're going to want to check your governing documents to make sure that your documents allow for voting suspensions as a means of enforcing a delinquency. Okay, there was a case out there. It was a condominium case, but we also take a lot of guidance from those condominium cases because they often apply to homeowners associations, just like the Kaufman language. Then Kaufman was a condo case. So look at your governing documents and make sure that you do have this authority. But the association can suspend an owner's voting rights if they're more than 90 days delinquent in any monetary obligation to the association, just like with the use right suspension for the same reason, done by the board at a properly noticed board meeting. Written notice then gets sent to the owner, mail, hand delivery, email, and then the suspension ends upon full payment of the delinquency. Suspension does not affect those common areas that are required for ingress to, egress from the lot, for utility services or affecting the right to park, and will apply to all of the multiple lots owned by a member. Once that voting interest is suspended, it's as if it doesn't exist. You're not counting it toward the total number of voting interests to determine a quorum, to approve an action, including elections. So the suspension, it's as if it never existed. Now, let's say you've gone through the process, you're still not obtaining compliance of the member. What do you do next? Well, generally speaking, the next step is to institute pre-suit mediation. Here it's considered mandatory pre-suit mediation because it is a requirement to go through mediation before you can go into court. Now, there are certain disputes that are required to go through this pre-suit mediation process. When the dispute involves use of or changes to the lot or the common areas, amendments to the association's governing documents, board and committee meetings, membership meetings, but not election meetings, access to the official records, and covenant enforcement. However, there are other disputes that are not subject to this pre-suit mediation requirement. It can go directly to court or the division. Collection of any financial obligations. So they're not going to deal with money. They're not going to deal with title. They're not going to deal with landlord-tenant issues. Any action to enforce a prior mediation settlement agreement, alleged breaches of fiduciary duty, and again, the election and recall disputes, as I mentioned before, those go to the Division of Florida Condominiums, Timeshares, and Mobile Homes, as they have jurisdiction over election and recall disputes. The procedure is provided for the mediation process in the Florida statutes. The aggrieved party has to first serve a written demand on the responding party to participate in pre-suit mediation. There's a form that's provided by statute to be served by certified mail, return receipt requested, with a copy by regular mail to the last address of the responding party as it appears in the official records of the association. The demand has to include a list of 5 certified mediators. It does also have to provide certain information regarding those mediators, like how much they charge, contact information, things like that. The responding party is required to select at least one of the mediators that's listed, and has to provide a response to the demand within 20 days from the date of mailing by certified mail, return receipt requested with a copy by regular mail to the address of the aggrieved party as it's provided on that written demand. The mediation has to be scheduled on a mutually convenient date and time and take place within 90 days of the date of the written demand. However, that can be extended by agreement of the parties in writing. The parties are required to share the costs of the mediation equally, including the mediator's fees, unless the parties agree otherwise. A lot of times in these settlement agreements, you'll see that the association and the owner may agree to the payment of attorney's fees. And that can certainly be done in the settlement agreement. The pre-suit mediation proceedings are privileged and confidential to the same extent as a court-ordered mediation. Those people who are not parties to the dispute cannot attend that mediation conference without the consent of all parties involved, except for counsel and a corporate representative designated by the association. When mediation is attended to by a quorum of the board, it's not considered a board meeting for the purposes of notice and participation by owners. You certainly want to have someone there on behalf of the board who can settle the issue, because that's what mediation is all about, right? It's coming to an agreement with the help of a mediator to settle a dispute. So you want to be sending someone who has some kind of settlement authority there. Now, notwithstanding the association's efforts to get into a mediation room and sort things out, there are times when there is an impasse. And an impasse would entitle the party to proceed in court against the other party without further notice and to seek their attorney's fees and costs associated with the mediation process. Now, an impasse can occur when any party fails to respond to a demand or response, fails to agree to a mediator, fails to make payment of fees and costs within a time established by the mediator, fails to appear at the scheduled mediation without approval of the mediator, or the mediation can't be scheduled and conducted within 90 days after the demand was filed unless the parties have agreed to extend that 90-day deadline. Attorney's fees are awarded only if authorized by contract or statute, and that's the general rule. If the person who fails or refuses to participate in the mediation process wins in litigation, they cannot recover attorney's fees and costs in subsequent litigation relating to the dispute. So you don't want to be a bad actor in mediation. If a dispute is not resolved at pre-suit mediation, then the prevailing party in any subsequent arbitration or litigation is entitled to seek recovery of their attorney's fees and costs that are incurred in that pre-suit mediation process. If the dispute was settled at mediation, but an action seeking enforcement of that settlement agreement is sought, then the prevailing party in that arbitration or litigation proceeding is entitled to seek recovery of their attorney's fees and costs incurred in that pre-suit mediation process. So this is certainly encouraging parties to participate in the mediation process and to stick to their mediation agreement. Now, as I mentioned before, some associations governing documents do have self-help procedures. And self-help procedures are essentially providing the association with the authorization to go on the lot, do the work, and then assess the owner whatever fees and costs are incurred by the association in doing that work. This is extremely governing document specific. You know, if you don't have it in your governing documents, then you don't have it. If your governing documents do have it, there has been some recent progression in Florida's case law about how this self-help authority has to be exercised. Not necessarily, more so whether or not it must be exercised. If your association's declaration provides for self-help authority, then recent case law suggests that you have to minimally attempt to exercise self-help before filing a lawsuit to seek an order forcing the owner to do the work, which is an injunction, right? The reason why there's this case law in place is because typically an injunction is a remedy at equity. Ordering someone to do something is a remedy at equity. And remedies in equity are typically not awarded until all remedies at law have been exhausted. Remedies at law here being dollar bills. So if you seek self-help, you're able to do self-help and then assess for the funds to do it. That seeking the funds to do it is your adequate remedy at law, as opposed to going in equity and getting an injunction. Well, there has been a lot of disagreement between the district courts of appeal, which are the layer of courts right before you get to the Florida Supreme Court. And when there's a conflict between these districts, they can be certified to the Florida Supreme Court, which is what has been happening. The Florida 2nd DCA and Florida 6th DCA are those courts that have held that you have to at least attempt to exercise self-help before you file a lawsuit for injunctive relief. However, then the 4th DCA, which is where Palm Beach County is located, recently disagreed and held that no, the statute says the association has the right to seek relief in equity, even if an action at law is also available to, correct a violation. Meaning the statute doesn't limit the availability of equitable relief to situations where legal remedies are inadequate. So because of this disagreement between these courts, we're probably, going to see this being settled at the Supreme Court of Florida level. All right, and that's actually it for me today.
Well, that snuck
Let's
up.
see here. Yeah, that did sneak up. Usually, I feel like, you know what? I think maybe since we updated it to meet the requirements of the 2025 legislative session stuff, we've cut out a few things.
And I just
but don't
placed
worry,
the
like support animals, emotional support animals, all that stuff. We used to talk about that stuff, but you know what, guys? We offer those courses separately. You can go to kbrlegal.com on the calendar. Look at our calendar. We usually schedule them. So keep an eye out.
Yeah, today we'll be adding a bunch, and Courtney and I, we were chatting behind your back while you were teaching, talking about getting some stuff in the books with GRS as well. So, but great job. You didn't lose your voice one time. That was.
I know it, right? I'm getting better. It must be, I just got back from Disney, and I have two very small children, so it must be all the exercise my vocal cords got at yelling at my children. To behave
Yelling
in
at your
line.
children and yelling during the parade, right? So
Yeah, exactly.
there you go. So folks, if you haven't already done so, something we mentioned at the very beginning, press the chat button so that it appears on your interface. Because if you haven't pressed your chat button yet, you will not see the link that we placed there for the evaluation just a couple of moments ago. So press the chat button. We'll place the link in there once again. That is a requirement, and it's an extra layer of proof should we ever get asked by the division to help prove you were here. We have the attendance sheet from Zoom and the evaluation to help prove that you were here. And we want to know how we're doing. So the evaluation will help us know how we're doing and what you want to see in the future, both from us and from GRS. Before you get to some of the Q&A, if you have the time, of course, and you want to do a handful of questions, we're not going to get to all of them, folks.
I'm going through some of them right now.
Yeah, there's a bunch. We'll get to a few. Before we do that, I just want to mention to everybody that after you submit your evaluations, the required part is done. You don't have to hang out. Okay, it's the course material and the evaluation. Then you can go. And keep in mind that certificates will be sent to you to the email addresses you used when you registered. So I understand some of you might have accidentally used somebody else's attendance link. So keep in mind that if you don't get your certificate within 5 to 7 days from now, let us know and we'll send it to you directly that way. Keep tabs in your spam and junk folders. After the ladies answer some questions, I will come back and I'll share my screen. For those of you still having issues with your evaluation, I'll show you how to do it and how to save the slides. Ladies, back to you.
All right, so I'm looking at some of the questions. You guys have some good ones here. So the first one I'm looking at right now is from Sharon. Sharon says it was stated that agendas need to be posted 14 days before a meeting. Is this new? We go by sending out agendas for monthly meetings at least 48 hours in advance, which is correct. Well, I don't want you to confuse apples and oranges. So if we're talking about a board meeting, you do have to have an agenda on your board meeting notices, and typically a board meeting notice must be posted conspicuously in the community at least 48 hours in advance. There are those three different meetings, special meetings for boards. If you're adopting a resolution to establish online voting, if you're levying a non-emergency special assessment, or if you're adopting rules regarding parcel use. Those three board meetings will require 14 days notice sent to the members and conspicuously posted within the community. Now, if we're talking about a membership meeting, that's a 14-day notice requirement as well. Agendas must be provided for your special meetings. They're not statutorily required for annual meetings. However, I do suggest that you do include an agenda for your annual membership meetings as well. There's another question here from Martin about elections at an annual meeting. Meaning they haven't had a quorum at their annual meetings, so they've had a rollover board. There's mention of term limits here. Well, there are no statutory term limitations provided in the Homeowners Associations Act. There is a term limitation provided in the Condominium Act. And even there are exceptions to the application of that. But in HOA, Chapter 720, there's no term limitation. So, if your governing documents require a quorum at your annual meeting, and you don't get a quorum, yeah, you're going to end up having that rollover board situation. Let's see. What are some reasonable rules for recording of board meetings? So generally, it's like you have to provide at least 24-hour notice, or you have to set up the equipment prior to the beginning of the meeting. Whatever device that's used can't be emit a light or sound that would disrupt the meeting. You can't move the device around the meeting room, things like that. We pull that kind of guidance from condominium land, from the Florida Administrative Code, where the division has certain guidelines for condo rules. And we use that as a reasonable guidepost for our homeowners associations. Will will board members for non-condos receive CEUs for a day? If non-condos, well, if you're cooperative, no. If you're an HOA, yes. What financial info can be shared with the members? I don't know if association financial information is pretty, it's going to be accessible to members. I mean, they have the financial reports, your budgets. I don't know if you mean for the members themselves. You certainly want to be careful with any members that are delinquent, and you don't want to be sharing personal identifying information. Yes, meetings can be recorded for minutes to prepare minutes. You can do that.
Can I ask you potential curveball question. That person
Yeah.
just brought up about recording the. So I know condo's different. This is not a condo class, but if an HOA meeting is recorded, a board meeting is recorded, does that have to go on their website too?
No.
Okay, so never mind. Forget my question. Pretend I didn't ask.
Yeah, I don't see, because the HOA statute was not amended to incorporate video conferencing, which is what they
Right,
call it,
right,
under the condo statute. So
right,
the requirement to post those recordings was added because of the video conferencing stuff.
right.
Um,
I mean,
so
where I was going with that is, if you're not, if you're just recording it simply for meeting purposes, is it this? I was going to ask, is it the same thing as the meetings being recorded, but it's only being recorded by the secretary for the purpose of recording minutes afterwards. So I guess
yeah, and I mean,
that's more of a
if we're
condo
following,
question, not really here. So
yeah, and you certainly can do that, and you don't have to maintain that recording once those minutes have been approved. I mean,
okay,
if it's only being recorded for the purposes of preparing minutes, once the minutes are approved, and you can dump the recording.
okay.
Um, um, oop,
Vicky in the chat, I'm going to go over the evaluation. I see you and a couple others are struggling with some of the technology. When the ladies are done with the questions, I'll share my screen and show you some of the common things that happen as to why it may not be working for you.
so here, Dominic's asking a question. HO with 100 more homes needs a website, correct? Yes, that is correct. If you have 100 or more parcels, you need to have a website. Condos did change to 25 units as of January 1st of 2026.
Websites are a good idea, whether they're required or not, because if you train your
Right,
owners
right.
to go look on the site for stuff that people normally call your office for, it can help with your productivity.
Yeah. And he's asking more so like, why is there a difference? Why does it seem so unfair? You know how many differences there are between the condo laws and the HOA laws? Like it's mind-boggling that they are very similar, but like I said, there are so many differences between the two, and it's in minutia like this. um that those differences lie. Why is it different? I have not a clue. Not a clue. Legislature likes to play games with us, I suppose. Um
No, it's perfect every time. What are you talking about?
yeah, yeah. I mean, they really do make changes, and sometimes they're just in isolation. Like that one change when I was talking about the governing documents, amendments to the governing documents. The provision requiring notice within 30 days of recording the amendment, you either provide a copy of the amendment or notice that the amendment's been approved, and providing the recording information for the amendment and saying, hey, you can get one at no cost. That was in existence prior to the legislature putting in there the requirement to provide a copy of the covenants and rules, and then providing a copy as they're amended. Clearly, whoever did that change didn't think about that 30-day requirement that was in place. And it's a 30-day requirement that doesn't have a penalty if you don't do it. So there are a lot of things the legislature changes that they end up creating these gaps, and then they have, these gap fillers, or the I forget the exact term that they coin it for the changes in the legislation
And
to
folks putting
fix.
questions about class material in the chat. The ladies are not looking at the chat; they're looking at the Q&A. So please don't put your course-related questions in the chat. Put them in the Q&A module.
I see a couple of questions here about the size of the board and changing the size of the board without membership approval or what have you. The board size is usually provided in the articles and or the bylaws, and those will typically provide how the size of the board is set. If there's a range provided. Sometimes governing documents will provide a stated number. And I find that if your association has staggered terms or wants to establish staggered terms, best to have a stated number of directors, because once you start getting into changing the number of directors on your board with staggered terms, oh, it becomes an administrative nightmare. So look at your governing documents, check out your articles, check out your bylaws.
Thomas and everybody else asking this question, how do you know my full attendance has been noted? The reason we tell you to register on your own and do not share your join links is because each link is unique to each one of you and tied in with your registration information. Every time you enter and exit, Zoom tells us, and we know via the timestamps whether you were here in full or not. So, Thomas and others, I hope that answers your question.
So here's a good question from Barbara. Is a physical location required for board meetings, or can you do the meetings exclusively by Zoom?
Hmm. We were talking
Well,
about that before we went live on the air.
so you really should be, if you're offering Zoom, you need to have in this humble attorney's opinion, you need to have a physical location.
And she is
You know,
humble.
Florida, um, and honestly, because the condominium statute was recently amended to provide and expressly allow for video conference meetings, and the HOA Act was not similarly amended, really adds to that argument that you can't have a Zoom only. And it's really not as crystal clear in the HOA Act that you have to have a physical location, but considering all the factors involved, best to have that physical location. If you want to have Zoom as an option, have a computer, laptop, something in that physical location.
I was going to say, as the non-attorney of the bunch, I'm the nerd of the firm here. Not everybody's tech savvy. Okay, so that's why the legislation has stuff in there about having to have a place for people to go, because if you do it with a technical aspect only, you're potentially automatically shutting people out from something they're supposed to be able to see.
Mhm. To avoid records requests, is it an option to have everything available online for members to view, with exception to legally protected documents? So having everything online for the members to view is great, but it's not going to stop people from sending in records requests. When you get the records requests, though, you can tell them, hey, all these records are available online, just go here. It makes responding to official records requests much easier. And again, you don't want to be posting up things, documents that are not subject to access of the owners, like medical records, anything with a social security number. If the document is required to be posted, you want to be redacting any of that information that is not supposed to be disclosed to the members.
This is one from very, very early. If bylaws state an HOA board can take action by written approval of the required number of directors, can the board vote by email?
No,
Okay.
still no voting by email.
Do one.
And quite frankly, for me, even if your governing documents, the bylaws would allow a owner-controlled board to act by written consent. First of all, any action taken by the board by written consent would have to be unanimous. It's not something that the board can just, oh, majority of the board approved it in writing. No, no, it has to be unanimous to begin with. And second of all, I have a problem with association boards making decisions outside of a board meeting, because how do the members have the ability to attend and speak? I mean, it just, to me, it flies in the face of the spirit of the law. But that's me.
Yeah. Thanks for pointing out that I think somebody was messing with me. Somebody pointed out that I had Esquire BCS after my name, and I didn't say that about an hour ago. I was anyway.
Oh, that's funny.
Somebody else must have logged in and logged out.
Do all the specific votes of the board need to be recorded in the minutes of the board meeting? Yes. Answer to that is yes. The vote or abstention for each of the directors needs to be provided in the board meeting minutes. Can a board member attend a board meeting by phone or Zoom? Yes, they can. You just have to make sure that whatever device that you're using to attend that meeting is in the meeting room and everybody can hear you and people can be heard by you. You just want to make sure that there's participation, the ability to participate.
Do one or two more, then we'll get to the tech aspect because I know people are getting antsy.
Oh, yeah. So here, what to do if a member wants to resign and cannot find a replacement? It seems difficult to find volunteers that want to join the board. I agree with you. It is difficult. Like I said, the
Because the pay
pay
is so
sucks.
good. The pay is so
The pay
good.
sucks. There are lots of criminal charges that you could catch
Yeah.
if you make a bad decision, whether you know it was a bad decision or not. And yeah, I mean, so long as look at your governing documents. Sometimes filling the vacancy is something that is discretionary. Maybe it's a may and not a shall. Minimally, you need to have enough directors to establish a quorum of the board in order to conduct business of the association. If you're unable to obtain a quorum of the board, well, then you're staring down the barrel of a receivership. And usually, when you tell your members, hey, we don't have enough board members, people who are willing to participate, we're going to have to petition the court to appoint a receiver. Receivers are six figures plus per year to run our association. They may volunteer
Hmm.
as true because they don't want to have to pay the receiver, and they're not cheap. Um, what is meant by an affidavit for saying notice of the board meeting was posted? You don't need an affidavit for posting notice. You only need an affidavit when you're mailing, delivering, or electronically transmitting notice. And the affidavit's just a sheet of paper that has the notary block on it that says, I, Danielle Brennan, as whatever attorney, LCAM attorneys we don't do the mailings, but Courtney Bucam as manager for this Sunshine Association Inc. On this day, sent notice of the membership meeting to be held on such and such date, blah, 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 on this day. And then you sign it, you have it notarized, that's your affidavit. And you don't send the affidavit to the members. It's something that's kept with the association's official records. Um, This is an interesting question from John. Should an election committee be selected ahead of the meeting to handle mailed in ballots? Remember that your election is very specific to your governing documents. Some governing documents have a nomination committee, where you have a committee and they get resumes or notices of intent from owners, and then maybe you have that pre-nomination process and you also have nominations from the floor. Your documents may or may not require an election committee. Generally speaking, in meetings that I attend, I like to have people who are there at the meeting, and I'll say, okay, we need some volunteers who are not directors, officers, employees, or any of their spouses, anyone living with them to tally the ballots to make sure that there's no funny business with the ballots. You don't have to do that before the meeting. In fact, it's more of a procedural headache to do it before the meeting. Usually the mailed in ballots, if you have absentee ballot requirements, are put into a locked ballot box. And then that ballot box is brought to the association's
Mm.
place. All right.
Last one. Are we done?
I mean, it's not quite 1 o'clock yet. I don't know if you want to
Okay.
run to one.
Do one more, and then I'll go over the evaluations for everybody because some folks are having some technical issues. So do a couple more. You're right. We did advertise for 3 hours. You're correct. I also want to be mindful. I don't want you passing out on a live Zoom session. You might be hungry.
Um, Let me go more to the top because I'm getting the one saying, thank you, which I love. Thank you.
Yeah, no, we appreciate you all being here. And again, Courtney, GRS, thank you for inviting us to co-collaborate here.
Thanks for having us.
My community is listed as a nonprofit community. Yeah, like most. Can vendors charge a sales tax on goods? Well, the charge of sales tax doesn't have to do with the association. It has to do with the vendor. I'm certainly not a tax expert, but the requirement is on them, not on the association. My understanding is that before this is from Dominic, and I'm reading it to what I believe is what he's saying. So my understanding is that before expiration of the date of the declaration, the association go to the courthouse and file some legal documents which will preserve the declaration for a minimum cost. This is legal, correct? Yes, it is correct. You're referring to the Marketable Record Title Act and covenant preservation under the Marketable Record Title Act. There are 3 ways to do it. And like I said, the easiest way is by a summary notice that's permitted by Chapter 720. And it is a very simple document that gets put together. The board approves it. It gets signed by the board and gets recorded with the county's official records. And then you're good for another 30 years. Your declaration is good for another 30 years.
John, I'm from Queens. And the reason I sound like Howard Stern right now is because I have a bad cold.
Yet he's still with us. Hopefully not sharing his germs via the microphone.
Technology hasn't gotten that good yet, I don't think.
All right. Well, I'm good. If you guys have any other questions that are general, I know a lot of you had like a longer questions and I skipped over it for that reason. Like I said, I do try to be a good girl and respond to those with the time that I have provided, the extra time I have provided. So I try not to ignore you.
No, we appreciate that. The Q&A is bonus. The required part is, and the important part is getting everybody certified. So Danielle, thank you so much for spending your time with us. I know you're going to be back again next month with doing half of the condo cert with Andy, so that'll be fun.
Oh, Andy, I thought it was okay. Andy, I thought it was Alan, but that's no big deal.
Yeah.
Either one is fine.
Still have still starts with an A, right?
Yeah.
All right. Well, Danielle,
all right, thank you very much. Thank you, Courtney.
Thank you, Danielle. Good seeing you.